Okay.
Chief Justice, Deputy Chief Justice, Your Ladyship, my Lords, Justices of the Supreme Court, my address will be followed by Apollo Boya, who acts for Cherera, the Vice Chair, followed by Jotham Arua, who acts for Commissioner Justice Nyang'aya. He'll be followed by Jeremy Jenga, who acts for Commissioner Francis Wanderi, followed by Gordon Ogola, who acts for Commissioner Irene Masit, and then finally Mansu Issa, who will address the court on behalf of the 4 commissioners collectively, as I will be addressing this honorable court on behalf of the 4 commissioners collectively.
So are we giving each one of you 10 minutes? Or within the 1 hour? So we put there 1 hour?
Yes, we'll distribute amongst ourselves. Yes. We hope to do it within that 1 hour. Your Ladyship, my Lords, the first submission, fundamental submission I'd like to make is that when this honorable court retires to consider the judgment it will deliver, this court be guided by the fact that it is the position taken in this court by the 4 commissioners, being a majority of the IEBC, that should inform this court's decision, not the views of the minority. The official position of the Commission is as per the views and affidavits of a majority of the commissioners. And that has to be so in law. The reason being that under the Constitution, and in fact under the statute, the IEBC is a corporate entity. Therefore, in the absence of consensus, its decisions as an institution are by the majority. So do not depart from that principle, a principle that has found judicial anchorage and recognition in a number of decisions cited by my colleague Paul Mwangi, the minor KI decision, the Michael Kamau case, and the other decisions. Corporate decision, and that position has been addressed, and I do not want to take the time of the court by going through it again. With regard to each one of these 4 commissioners, I ask this honorable court to bear in mind that each one of them went through a very rigorous vetting by the National Assembly, at which there was full public participation before they got appointed, so that anyone who had any issue with any of them, that was the time to raise the issues. Again, the law is clear about how one can complain about a commissioner enjoying constitutional security of tenure. So do not be influenced with innuendos and insinuations about these 4 commissioners. They were vetted by the people's elected representatives. Now, coming specifically, this is the second fundamental submission I'd like to make. This so-called walking out from Bomas. Look at the affidavits of the 4 commissioners. The vice chair saw 2 affidavits, so there are 5 affidavits in total. And I invite this honorable court, when it retires, to read through those affidavits in their entirety. We adopt them. We rely wholly on the averment in those affidavits. And you will find in those affidavits that all that these 4 commissioners were demanding of the chair at Bomas at the tail end of the tallying and the verification. Their narrative, which I invite this court to accept, is that they were not involved in the tallying and verification, and in particular regarding the 27 constituencies. So they were demanding of their chair, you cannot bring a paper here and tell us that these have been verified and tallied by the chief executive. The work of the chief executive is to implement decisions of the commission. He is not part of the commission, any more than the registrar, the chief registrar, implements, or any registrar of the High Court, implements the decision of the judges, not the other way around. So they were saying, we need to tally and verify the results in respect of these 27 constituencies. And the chair would not allow that, which was typical of the relationship between the chair and these 4 commissioners. And a twist is being given that it is these 4 commissioners that wanted to force a runoff. It is the exact opposite, your leaderships and my lords, and that is what we state in the affidavits. It is them who were asking, how do we confirm that the candidate you are about to announce has received 50 plus 1 votes? And his response was, are you trying to force a runoff? I am not conducting another election. So this acrimonious relationship is what was there between the chair and his 2 allied commissioners and the other 4 commissioners. Now, I would like to submit that the 4 commissioners were fully justified in saying we cannot own results we have not tallied and we have not verified. The law has been referred to this honorable court severally, that it is the commission that should do the verification and the tally. This legal notice that appointed the chair as the returning officer, you've been invited to hold that legal notice, that regulation is unconstitutional and valid because it contradicts the Constitution and the Elections Act. But beyond that, it is the chair himself alone who appointed himself as the returning officer for the presidential elections. You will not find any minutes of any meeting by the commission appointing the returning officer. So quite apart from the fact that it was unconstitutional, it did not have the authority of the commission. I would like to cede ground to my colleague Apollo so that we operate within the 60 minutes accorded to us. I ask that this court uphold the position of the 4 commissioners, that the results that were announced were not the results tallied and verified by the commission. I thank you.
The Chief Justice and members of the court, without wasting more time, I'll pick it up from where the senior counsel has left. My name is Apollo Mboya. I am on record for the fifth respondent. Your Ladyship and my lords, the actions of the chairman of the Electoral Commission can be evaluated using several instruments. And I believe the first instrument that we need to use in examining the whole issues that are before this court is the oath that the commissioners take. The oath is in the third schedule of the IEBC Act, so that for every action, we juxtapose that oath to those actions, so that we test if the actions meet the tenets of that oath. And permit me to read what that oath says, and it's taken by all the commissioners. It states, I, then they say their name, having been appointed chairperson or member, as it can be, of the Independent Electoral and Boundaries Commission, do solemnly swear that I will at all times obey, respect, and uphold the Constitution of Kenya and all other laws of the Republic of Kenya. That is the oath they take. That I will faithfully and fully, impartially, and to the best of my ability discharge that trust and perform the functions and exercise the powers devolving upon me by virtue of the appointment without fear, favor, bias, affection, ill will, or prejudice. That is the promise that they are giving to the people of Kenya and to the whole world. Now, for every action that the chairman did, which I'll not go into because this particular affidavit of the fifth respondent has been cross-referenced by my other senior counsel and also learned colleagues who spoke before me. We juxtapose those actions against that oath that they took. So, for example, if we are talking about issuing a gazette notice, you look at that gazette notice with the law, then juxtapose it to the oath, if it meets that promise that they gave. Your Ladyship and my lords, the fifth respondent is now affectionately called opaque. Affectionately. I say that because arising out of what transpired at the National Tallying Center, the four issued a statement in which they said they cannot own the results that were going to be announced by the chairman, and therefore they were opaque. Your Ladyship and my lords, that term opaque is not coming from the ordinary. It's a term that was given by the Court of Appeal when they were making a decision in another matter, which is now famous here, called the Maina matter, which when they were looking at the role of the chairman vis-a-vis the other commissioners. And the court did indicate that to suggest that one individual alone can tally and verify the votes for presidential election is to suggest otherwise, to introduce opaqueness and arbitrariness to the electoral process. Those were the words of that court. Members of the court, we might ask if the chairman, as indicated from the affidavits that we have had, that it was his responsibility alone to tally and verify the results. Then the question is, what were the other commissioners supposed to be doing on that election day? Were they supposed to sit at home and watch the screens just like any other Kenyans? But then again, the chairman went ahead and allocated them duties. With respect to the fifth respondent was given the role of media. In that role, the fifth respondent was supposed to explain even to the media why what they were reading.
Office to shield himself from legal scrutiny. How is that? Take a look at that. And finally, 500,000 ghosts voted, Mutata alleges. 500,000 ghosts voted, Mutata alleges. He was there yesterday at the Supreme Court giving an account, on the slide on how the numbers did not add up, and that is how it happened. You can take a look at that story. And finally, here it is, missing Uhuru takes Mombasa by surprise. Nobody saw him going to Mombasa, and boom, he was seen for the first time in public. And that is as far as the Daily Nation and the Star newspaper is concerned. Over to you, Ben.
And when we started out, I started out with the Bible verse, Proverbs 18, verse 17. We say the first to present his case seems right till another comes forward and questions him. Why I say that is because today we are expecting President-elect and the IEBC to defend themselves after Azimio had the day in court. And I will try as much as possible, Vicky, not to repeat what you've said, but looking at the standard, tough questions as Raila lays out case from discrepancies, infiltration of IEBC systems to disunity among commissioners. The legal team is trying to convince judges to overturn William Ruto's win. But the judges yesterday did ask some very, very critical questions, and you have mentioned some of those questions. Of course, the calculations of 50+1 forming basis of this divided commission, IEBC contradicting figures. They say there was system reduction of votes cast for Raila, which were added to Ruto in several constituencies. Requirement to declare winner does not give chairman power to tally, verify, and decide the winner. This is something also raised. Forms used in election do not match what IEBC said it would procure. And postponement of governor election in Kakamega and Mombasa gave Ruto an advantage. And the Kim's kit failure also talk about failed in several Raila strongholds and delayed voters, discrepancies in the results, among others. There's some of the issues that have been raised, but as Vicky, you've put it, the judges did ask some very critical questions, talking about how did the voter suppression, they want them to prove. They want also every citizen has a right to participate in an election, but how then do you reconcile argument on Article 89 because constituencies don't vote, citizens vote? That's some of the question or pertinent issues that have been raised by the judges as they seek to try and make the opaque, as the four commissioners said, they are trying to ensure that now we have a transparent result on the same. 2, 3, 4, 5, all talking about the supreme battle. There is also a profile of the top lawyers, including former AG Githu Muigai. We have seasoned lawyers Kioko Kilukumi, Githure Kindiki, Paul Muite Orengo, Fred Ngatia, and Paul Mwangi, just forming part of the legal council representing both sides. And in total, we have over 100 lawyers, not to mention the other lawyers who are playing the strings from the back as they try to put things into perspectives. And moving on, Mutata also raised about the issue on fictitious votes, as Olo has called them, ghost voters, where he's talking about 1.6 million Kenyans who cast their ballot for the presidential results after the polls closed, 1.6 million. The court would want to know exactly what transpired, because Omtata talking about Kim's kit transmitting results 23 hours, way after the elections had already been closed. Of course, there are discrepancies that have been found in the scrutiny of the forms for the 15 polling stations, that those have been recounted. And in the Standard, they have a pictorial here on how the judges, how the lawyers, the security, the ballot boxes, the tallying, and of course Kenyans waiting eagerly to know exactly what is happening. But away from matter supreme, because today is the second day of full hearing, we'll be crossing over a little bit later. But Vicky, I've noticed something that I heard about it on Monday. Families burying their kin in sacks, blame it on poverty. They say they're buying a sack at 50 shillings and they don't even need a church service, and the burial takes about 20 minutes, just to underscore the inflation in the country, the high cost of living. And it's a village in Ndindiroku, village in Kirinyaga County, where they are urging locals to join and help burial welfare groups, because they want their kins to be buried in a dignified manner. Yes, indeed, the games are back. The music festivals for our kids are back. And in Rift Valley, it was no exception, as the Rift Valley Regional Secondary School Music Festival that was supposed to be kicking off yesterday will be kicking off next week. Moving on, Mungaro Tours Ailing Hospital. When it comes to matters health, the governor seems to have started out by checking out the ailing health sector. This is Mungaro in Kilifi County. We have Cecily Mbarire in Embo County, and we've heard of the Nakuru governor also touring the hospital and pledging. And actually, in one of the stories that we ran a little bit earlier, they waived 5 million shillings in bills. And talking of health, a man commits suicide after cancer diagnosis. A 60-year-old man, after the diagnosis, he took his life by hanging himself. And moving on, NEC has released timetable for CBC and 844 exams. All schools have until September the 9th to download and administer examinations under the competency-based curriculum. The grade 6 summative assessment will see learners assessed in English, Kiswahili, mathematics, home science, agriculture, science and technology, creative arts, moral and life skills, and physical and health education. You can find that on page 11 of the standards. And back to matters polls, there's a report revealing counties where women were assaulted. We had cases of them being intimidated, their billboard being defaced, and a study by Feed.
The results they were reading are not being projected on the screens. The results that they read were not projected from Friday 13th. And when that question was put to the chairman to refresh, the chairman said, no, I'm tallying from the back end. Your ladyship and my lords, the sum total of this whole transaction is that the chairman usurped the powers of the commission. And it's our submission that after all is said and done, and after we get the reports of the verification, I believe that this court will arrive at a conclusion that the chairman of the Electoral Commission was actually an agent of a presidential candidate. That presidential candidate we will know by 5th of September. And if that's going to be the case, lastly, it's our submission that this court must go further and look at the theory of agency. All the conspirators that did any illegalities, all irregularities, are agents of one another. The person who benefited from those irregularities and illegalities is a co-conspirator with the persons who perpetrated it, and they are agents of one another. And for that reason, we would urge that this court makes appropriate decision with that particular issue in mind. I call upon my learned colleague, Dr. Marua, to take over from me. Thank you very much.
The Honorable Chief Justice and the honorable members of the court, my name is Jotham Arua. I appear for the 7th respondent, Commissioner Justice Nyang'aya. I will be making submissions on the following issues. Issue number 2, whether there was interference with the uploading and transmission of Form 34As. I'll also speak to the issue whether there were irregularities and whether the irregularities affected the results. I'll mention briefly something to do with the reliefs that this court ought to make, and also issue number 6, whether IEBC carried out the verification exercise. So on the first issue, my lady and the honorable members of the court, the position of my client is that there were indeed interference with the uploading and transmission of Form 34As. My client maintains that this was done without the involvement of the commissioners, specifically the 4 commissioners. And it is their position, my lady and the honorable members, that it was done in clear violation of Article 81E of the Constitution and Article 86. Before I proceed, I wish to clarify that we have made reference to a number of authorities in our written submissions, but I will not refer to them because of time constraints. As regards interference with the ICT infrastructure, the Commissioner, in his affidavit, which has been filed before this court, and specifically in paragraphs 33 to 34, raises a number of issues. First, he maintains, my lady and the honorable members, that the server was accessed by unauthorized persons, and these included foreigners and some members of the IEBC. He mentions them by name. He further maintains that one foreigner by the name Gudino Omar accessed the server several times. He explains that a number of forms were pulled down and others uploaded. And he also maintains that there was revision of Form 34Bs. My lady and the honorable members, these allegations are contained in his affidavit, and I wish to point out that they have been responded to by IEBC. In their response, the first thing I wish to point out is that there is no denial that the logs that he annexed to his affidavit emanated from IEBC. The only contention being raised is how did he get them? That contention, in our humble submission, has no merit, considering, as he puts in his affidavit, that he was the commissioner in charge of ICT at the commission. If a commissioner who is in charge of ICT cannot access that kind of information, it is my submission that nobody else in IEBC can access them. The next thing that, and that admission, Madam Chief Justice and the honorable members, is found in the affidavit of Hilda Kavonga. That affidavit is filed by the firm of Iseme Kamau and Maema Advocates and is sworn on 27th of August 2022. And the admission is contained in paragraph 13, Roman 4. Beyond that, Madam Chief Justice and the honorable members, there is also an admission, and this, according to me, is a serious admission. There is an admission that the server was accessed by a foreigner by the name Gudino Omar, as mentioned in the affidavit of Justice Nyang'aya. But I wish to read to the court what is said as concerns this foreigner. At page 5, paragraph 13.7 of her affidavit, that is Hilda Kavonga, she says, Gudino Omar is the technical lead for Smartmatic, who provides support on the technical by a foreigner from a distant location. What is the guarantee that this foreigner will not grant further access to other unauthorized persons to commit all manner of mischiefs? But more important, Madam Chief Justice and the honorable members, is the complaint by Justice Nyang'aya that Gudino Omar was uploading and downloading forms. There is silence with regards to that issue. Then there was the contention that other unauthorized IEBC staff also had access to the server. And their names were provided, Madam Chief Justice and the honorable members. In the replying affidavit by Hilda Kavonga, again they make this admission, and with respect to one Abdidahir Maalim, it is argued, and I'm referring the court to paragraph 13, Roman 6 of Hilda's affidavit. She says, Abdidahir Maalim was a returning officer, and this access was limited to transmitting Form 34Bs and not to any other function. Madam Chief Justice and the honorable members, the list of all the returning officers, who participated are included in the affidavit of Juliana Cherera and specifically marked as Annex J C2. Unfortunately, the name of Abdidahir Mohammed does not appear. It is not indicated with respect to which constituency or which county he was the returning officer. It would appear clearly that there was a lie. Beyond that, the logs that were filed by Justice Nyang'aya were also analyzed by a forensic analyst, George Njoroge. and he submitted an affidavit to which he annexed a report. And in that report, Madam Chief Justice and the honorable members, it is clarified that Abdidahir Mohammed accessed the server more than 1,000 times. The question one would ask is, according to the Constitution, it is not only verification by IEBC that is required. Verification is supposed to happen at two levels. First, by IEBC, but secondly, that has been referred to by my learned colleague, Apollo Lomboya. But then there is the issue of verification by IEBC, which also did not happen and could not happen given the circumstances of this matter. Madam Chief Justice and honorable members, you have been told how 4 IEBC commissioners were sidelined in the entire process. It is our submissions that it could not have been the intention of Kenyans that IEBC commissioners be reduced to spectators in a presidential contest. That is something which is inconceivable, and we would humbly urge this court to put a stop to this practice. There are other issues that I would have wished to deal with, but because of time, allow me to cede the floor to my colleague, Jeremy. Thank you very much.
Yes, my Lady the Chief Justice and the honorable members of the court. My name is Gordon Ogola, and I'm representing the 6th respondent, that is Irene Masit. I'll rush through my submissions because I don't want to give more time to my brothers. I've been sent here by the 6th respondent to tell the court and the whole world that she's not coming here as a second-tier petitioner. She's not coming here as a surrogate of anybody, but she's coming here as a demonstration of her undertaking to protect, uphold, and defend the integrity of the Constitution. Indeed, while taking oath of office, she undertook to carry out her duties in compliance with the Constitution. In that regard, the 6th respondent was alive to the fact that in conducting the general elections, they had to be guided by the provisions of not only Article 81, 86, and 138, but also Article 10 of the Constitution. My Lord, the 6th respondent submits that the manner in which the election process was managed by the 4th respondent up to and including the tallying, verification, and the declaration of the results flies in the face of the provisions of the articles that I've cited. As will be seen in the affidavit of Irene Masit and corroborated with the affidavits of the other form commissioners, the chairperson excluded the majority of the commissioners from the tallying and the verification process. In fact, if you go through the affidavits, you will note that the only duty that they were assigned or that they undertook as regards verification and tallying was when they were summoned by the chairperson to be given the results in the office. My Lord, and the other thing that they only did is after he told them, this is the results I'm going to read, was to give them the Form 34C. They did not take part in the tabulation of what resulted in Form 34C. My Lord, the 6th respondent had a legitimate expectation that as stipulated under 138(3)(c), that the tallying and the verification ought to have been done by the commission and not by an individual commissioner in the person of Chebukati. In fact, the exclusion of these commissioners did not start at that point while they were in Bomas, but it started at the point when he, Mr. Chebukati, unilaterally reassigned them duties that they would take at the floor of Bomas, which were completely at variance with the duties that they were holding as in the subcommittees that were running at the commission. My Lord, before the declaration of the results, the commissioners were expected to ascertain and satisfy themselves that whatever was being put into 34C was a true reflection of the contents of 34A and 34B, but they were never given that opportunity. My clients and the three commissioners have confirmed that they were not involved in the process at all that gave birth to 34C. My Lords, even during the declaration of the results done by the four commissioners, evidence that can be found in their affidavits shows that the only things they were given were handwritten pieces of paper with results in them. Those documents that they were given and which they were reading out to the public are not part of any accountable documents that can even be brought to this honorable court. Secondly, at the time of the declaration, my Lord, you will note that there were 27 constituencies whose results had not been verified. Even though the chairperson claims she accepts or agrees with the results that were announced, at paragraph 73 of her affidavit, she states that without verification of results from the 27 constituencies, I believe it was not possible to determine a winner in the hotly contested 2022 presidential elections, and to that extent, I cannot vouch for the veracity of the result declared by Wafula Chebukati on the 15th, for there was no transparency on his part towards the declaration of results and final figures and were not verified. I was kept in the dark by the chairperson with respect to tallying. That is her position. She cannot vouch for the results that declared William Ruto as the president-elect. My Lord, lastly, the conduct of exclusion by the chairperson of the other commissioners from vital activities of the commission was not limited only to the events that happened at Bomas. I will just cite a few. One of them was the manner in which he assigned the commissioners' roles to play at the Bomas. That was a unilateral decision. Secondly, the unilateral deployment, transfer, and gazettement of returning officers nationwide. That can be found in the affidavits of the sixth respondent at paragraphs 16 and 17. Then the third one is the deliberate failure to facilitate the contract implementation committee to oversee the implementation of the ballot papers, contracts, and task of inspection of the printed ballots at the vendor's factory in Greece. That is a function that ought to have been done to ensure that there was due diligence of the ballot papers that were being printed. That one, again, they were not involved, and that did not take place. Lastly, second last is the postponement of the elections in specific areas, including Mombasa, Kakamega, Kacheliba, Rongai, Pokot, South, among others. And lastly was the appointment and gazettement of the chairperson as the national returning officer. That, again, is not a decision that was taken by the commission unanimously. My Lord, in the end, it is apparent that in managing the affairs of the commission with regards to the elections, the fourth respondent as the chairperson deliberately created a dysfunctional system to aid and abet his criminal and evil acts that would be interpreted to mean that he had intention to subvert the sovereign will of the people of Kenya. We beseech you, therefore, to find that nothing good can come out of a dysfunctional body. I'll therefore call my friend Jeremy to continue.
Yes, my ladies, are opposing or supporting the petition. But the reality is this, that by him, and I think that's the position of the other, from the fifth to the eighth respondents, by telling the court the truth, by telling Kenyans the truth, what happened at IEBC before the elections, during the elections, and after the elections, by telling the court the truth. Unfortunately, they have no apologies for this. That evidence addresses some of the issues that have been framed by the court. One of those issues that, according to the eighth respondent, is addressed by his position, the one that is taken in his affidavit, is issue number 6. That is whether the IEBC carried out the verification, tallying, declaration of results in accordance with Article 138. My learned friends have covered that. The eighth respondent's affidavit has covered that. They were not involved in the tallying verification. So answering that question, the eighth respondent, it is his position that the presidential elections that were announced by the, I think, the third respondent did not comply. Now, the other issue that I want to clarify, my ladies and my lords, or maybe I should address whether the issue number 1, 5, and 7. Again, because of the peculiar nature of the way the IEBC is run by the chairman, it is the eighth respondent's position that despite being a commissioner, he cannot even help the court in addressing those issues because the results that were announced on the 15th of August, the system that had been put in place, the person who was in charge of them, it was not the commission, it was not IEBC, but that is the chairman. The chairman is the one who can be able to answer most of those questions. The results that were announced, his position is that those were not the results of the commission, those were the results of the chairman. Maybe the other issue that I should mention is that the 5th to 8th respondents, they've been branded all sorts of names. Some of them appear in the documents that are before court. Others have been mentioned out there. And my lord, what the 5th to the 8th respondents did by walking out of Bomas is because they did not want to give legitimacy to a process which they were not involved in. My lord, by taking my ladies and my lords, by taking the position they did, as has been mentioned by my learned friends, they took an oath of office. And the oath of office that they took was to uphold and protect the Constitution. When they realized that the Constitution was being abused, their role that they were supposed to play was being abused by the chairman of the commission, that's why they took that position. Did they take that position so that they could support any of the parties? My lord, that is not the position. They were just exercising their right, what they had taken oath to do, uphold and protect the Constitution. So all these names, the way they are being seen, that like they are taking sides, they are not taking sides because they had any interest in the outcome of the elections. They took the position they did because they wanted to uphold the Constitution. My ladies and my lord, we have there are some authorities in our list of authorities that we would kindly request that you look at them. I know you've been referred to authorities within Kenya. We have gone out of the country. We have some very good authorities from India, the Supreme Court of India. I will not take time to go through them, but they will be of great help to the court even as you retire to come down with your judgment. My lady, because of constraints of time, I will leave the remaining time to my learned friend, Mr. Issa.
Good evening, my Lady Chief Justice, the Deputy Chief Justice and Justice of the Supreme Court. My Lords and my Ladies and my Lords, in summarizing the position of the 4 commissioners who are now respondents in this consolidated presidential petition, Lords, we want to make the following submissions. One, as a commission, it is the position of the 4 commissioners that they did what was within their mandate to deliver a free and fair election as required by the Constitution. But in their quest to do what is right, what is required of them, there are problems that have been set out in the respective affidavits. And my Lords, the first issue that you would note that springs from these 4 affidavits by the 4 commissioners is a question of lack of transparency. On the day after the voting ended, and also predates the general elections. You'd note one thing that is common and that cuts through the 4 affidavits is that they were excluded from the process that was going on in terms of verification. And what is clear when you look at all these 4 affidavits is that yes, there was that process where they appeared to read results. These results, and they've said this under oath and has not been controverted, were the results that were being processed on the floor of the National Tallying Center. They were handwritten. And that's important because they were handwritten. They would come out and read them to the agents and to the nation so that for each and every constituency, and these results were per constituency, people would know that these results have been verified at the National Tallying Center. You would note that in this affidavit, for the first 2 days, from the 9th to the 12th, these results were being posted or they were being aired in a screen that was available to the agents, the presidential agents, and to the media. That screen was paused or it went off. In all the affidavits, they said and they requested that this screen should be on so that as we go progressively verifying and tallying the results, anything we announce here can be confirmed by both the presidential agents and by the voters who voted. That request was declined. The question is why? Why did the chairman refuse to put on those results and to verify the numbers that were being read to the nation? The second question that you'll see that arises in terms of the process of verification and tallying, that has been covered by some of the parties that have submitted today. You'd note that when that process reached the tail end, the 27 constituencies that had not been announced had not been publicly confirmed to have been verified. And in fact, when you look at the affidavit of Commissioner Wanderi, he says he had taken a break because he had been there overnight. When he came back, the first expectation was that these results would be confirmed, they had been verified, and that they had been announced to all the agents. The chairman takes the position there was no constitutional requirement or he had no legal requirement to do that. No, he had. Because the Constitution requires transparency and accountability. That is the process that takes place at the National Tallying Center. It is not a perfunctory exercise. It is not a ceremony. It is a constitutional process. And why this is important is that the document that was given to the commissioners by Mr. Marjan, as confirmed by Mr. Chebukati, was not a Form 34C. That was being undertaken not by the commissioners, but members of staff in the back office of the chairman. The commissioners did not see Form 34C, did not verify it, and they did not approve it before it was generated. In fact, in all of the affidavits, they say they never saw the Form 34C. What was given was a 3-page document, and that document has a problem. That document appears in the Vice Chairman's affidavit and the other 3 commissioners' affidavits. What you note about that document And that was generated by Mr. Marjan, as has been confirmed, and presented to the commissioners, is a summary of 47 counties. It does not have the results that are required to be confirmed and verified at the National Tallying Center of the 290 constituencies. Why is that important? Because at this point in time, before the Form 34C can be generated, these 7 commissioners, and I'm talking to them as a commission, needed to verify that what we have announced before the nation and to the presidential agents these are the results that has. We invest the billions that we invest in the commission, so that when this solemn exercise comes along every 5 years, that process, they take it seriously and they do it in accordance with the law. And the third issue about transparency. The commissioners were not aware of how many voters, and that figure was not confirmed at the time this figure was being given to them. The figures, and you'd note about the different figures that have been given, and in fact, I was asked to highlight this. When you look at the affidavit of Mr. Sonkuli, sorry, let me start with the chairman, Commissioner Chebukati, at paragraph 30 of his affidavit, the one that he saw, sorry, on the 26th of August. This is the one that has been prepared jointly by the firm of Gumbo and Company, my good friend. At paragraph 30, he gives the percentage 64.6. Verified, had not been verified and confirmed by the commissioners. In fact, that information was never given to them. The number of voters who had been confirmed as having voted biometrically had not been given to the commissioners. So yes, they cannot change any of the results, but the process of verification and tallying and the constitutional process of determining who has attained the threshold is a joint process by all the commissioners. And that's where they come and say, what is the voter turnout? They confirm that process, because yes, they cannot change anything in the Form 34, even if they see glaring illegalities, they can note them. 2, that transparency required, then they confirm, because this Form 32As are not transmitted electronically. They are brought by this individual returning officers from the 290 constituencies. There was a possibility. There were some places where voters could not be identified because their biometrics had a problem and they could not be, and then there was, and that was allowed by the Court of Appeal. The final resort was to resort to the register, the printed register, to confirm that these persons, because they had the IDs of were registered voters. That is also a solemn process, because then they confirm, out of all this, were there any other voters that were identified manually, and then that number is verified, so we can come to the determination whether the 50+1 had been attained. They were not allowed to do that. And they requested, it's not that because there was an oversight, they requested and the chairman declined. So this transparency at the National Tallying Center is critical, because as a commission, you have to come and defend the process from the Gazette notice that was issued in January of 2022 to the final declaration. And the fact that the chairman was stubborn is a question, as set out in these 4 affidavits, is that he has contempt not only for his fellow commissioners, but also for the voters and also for the people of this republic, as well as the institutions, because that's exactly what he was told as the chairman, not him as a person, in Maina Kiai, that the chairman of IEBC does not have that role singularly. That is a role vested in the commission. Failure to adhere to a decision that is binding on the commission and the chairman of the commission is contempt not only of the Constitution, but of the institutions, of the judicial institutions that have said this over and over again. And let me go back to the lack of transparency in the process. When you look at the affidavit, which is the most detailed of the vice chairperson of the commission, there was lack of transparency regarding even when the ballot papers came to this country. The chairman calls it the vice chairperson the night before the ballot papers are to land here, and tells, or you are aware that tomorrow we are getting ballot papers. The other commissioners were not aware. This is part of the critical process that was meant to be undertaken by the commission. So transparency is just not at the tallying center, it's about the whole process. Well, if you look at paragraph 8 of Vice Chairman of the Commission, Juliana Cherera, she says, when it came to the issues raised about the voter register that were being addressed in one of the petitions, serious issues have been raised by KPMG. And so that required prompt, because this process was already late, it required a plenary decision on how to address the shortcomings and the lack of integrity of the data in that voter register. The vice chair says they were excluded from that process by the chairperson. So if there was any problem with the voter register, it was meant to be addressed by the commissioners, because they take ownership of the voter register. They were excluded. He made the decision on how to implement the decision and even what to disclose to the public. So these are the processes we're saying. Transparency and accountability in the whole process, and Article 81 and 86, is just not about the final product that appears on the telly. It's about what the commissioners are meant to do. And lastly, when you look at the affidavit of Commissioner Justice Nyang'ai, if anyone was to be given access to the voter identification, the result transmission system, or the back end, the commissioners needed to know we are giving the following persons access and the following rights, so that if there's any query, they can answer on behalf of the commission. That information was kept away by the commissioners, from the commissioners. In fact, the commissioner in charge of that process. Lack of accountability and lack of transparency. And the chairman was in a hurry. There was one more extra day. Why was the chairman in the work that all the staff at the commission had done, but they were betrayed by the chairman? Thank you, Chief Justice and judges of the Supreme Court.
Thank you very much. It is now time for the judges to ask any questions or clarifications in regard to the submissions we have had today. We expect the answers when you will be making a rejoinder. We are not expecting the answers now. It's when you're making the rejoinder. I will start with the Honorable Justice Ouko.
Thank you, Judge President. I have three very short clarifications that I want to seek from the team representing the first petitioner. The first one, perhaps I can direct it directly to Senior Counsel James Orengo. What is the relevance of rejected votes when computing the results or the outcome of a vote? The relevance of rejected votes. The second one, I would have addressed it to Ms. Soweto, but the team can deal with it, and you are not answering us today. The postponement of elections in certain areas, and you say this resulted in voter suppression. That people wake up one morning to go and vote for a particular category of candidates, that I go to the voting or polling station to vote for an MCA, or is it called MC? That people go to vote for a senator, but not the other positions. Do we have any scientific nexus on this, or is it just an assumption that this happens? The last question for me is on the reliefs that most of the petitioners have sought. You were addressed by Senior Counsel Feroz Noroji and also Senior Counsel Professor Jenda on the relief in section 80, subsection 4. And I'm wondering, what are some of the elements that must be satisfied before the court can act or can grant the relief under section 80, subsection 4? That would be all from me, my lady.
Thank you. Justice Renara.
Thank you very much, Chief Justice. Thank you, Counsel. You've been most helpful to us, particularly to myself. I have 3 questions, 4, I think, very short ones. The first is to Senior Counsel Philip Murger. You addressed us on the PDF format of the forms, but in the pleadings, there is a JPEG question. Would you like to?
I would like to immediately correct that. It should be
Yes.
JPEG, not PDF.
Oh, okay. So it was JPEG. It was JPEG.
JPEG to CSV.
Okay. Would you then like to connect, because you addressed us, I think you didn't connect the JPEG to PDF and then you said CDF?
I will, but I'd just like to clarify that that was a mistake on my
part. Okay. All right. But just clarify when you answer so that we can get it right. And also in the context of the staging and tampering and so on, explain to us how that happens in real time. Give us, say, Kagera Primary School Form 34A. What exactly happened in your theory, because you say some of these things you don't have? How was Kagera Primary School interfered with the Form 34A? Number 2, Mr. Arua, and this could also go to the other counsel appearing for the commissioners. You've raised many issues going way back before the election. The Venezuelans, mistreatment by the chairman, we're not allowed to do this and that. But we saw your clans in public reading out results. And that's what I'm calling my acquiescence question. They did all these things until the 11th hour. What evidence do we have that this is not an afterthought, that they're not doing this in good faith? What evidence do we have, apart from the question of the instructions to counsel, the meeting they called? Why do we have anything showing that for the last 3-4 months they documented these grievances and that there was therefore a storm brewing? My own sense of things is that when you come only at the point of final declaration, how then do we trust that in fact there were issues before? Tied to that, what role did violence play at Bomas? Because we have the evidence of the chairman that I couldn't do this because I was attacked, Gulia was attacked, we couldn't announce 27 polling station results, constituency results. What role did violence play at Bomas? I think you need to explain that as the commission, which is what you've said. For Firoz Noroji, Regulation 87.3, you've asked us to declare it unconstitutional, declare it inoperative. Please address that issue in the context of retroactivity and retrospectivity. At the time these things were happening, it was the law. You're telling us to now declare it unconstitutional. What happens to events? And you know what I'm asking about this. Mr. Ndegwa, you made a very innovative, I must say, submission regarding the diaspora vote, the number of constituencies. In answering my question, please go back to Article 89.1. 89.1 says, there shall be 290 constituencies for the purposes of the election of the members of the National Assembly. We are addressing a vote in a presidential election. Please connect 89.1 with the presidential election. Otherwise, the way you left it hanging, someone would ask the question, what has this got to do with this court and the petition before us? I thank you, CJ. I thank you, Counsel.
Yes, let me just take up from where Justice Lenaula has with Mr. Ndwiga. Mr. Ndwiga, if you look at Article 38(2), every citizen has a right to participate in elections. How then do you reconcile that with your argument on Article 89? Because constituencies don't vote, citizens do. So again, prisoners, persons in the diaspora, how are they to be provided for if we are to follow your line of argument? My next question was to Philip Murgo. I was drawing a chart when you explained to us that what you're telling us is that in the evidence that you have is that the Form 34 went into the KIMS kit at the polling station to the constituency. Then between the constituency and the public portal, the Form 38's numbers were changed. They were changed in that sequence, if I'm to understand you. Now, I don't understand much about ICT, but I presume that at the polling station, when the KIMS kit takes the image, these forms are written in handwriting. How can you explain then, so that I can understand, how a form can be changed in handwriting? This is not typing, it's in handwriting. All these forms are being uploaded and changed, different people's handwritings. How does that happen? For Ms. Soweto, she's not here, but since we'll answer ballots into 6 ballot boxes, what we have then is 6 different elections, but on the same day. So if your argument is voter repression, then is the voter repression only to the presidential election? Or is that an argument that can be used by an MCA in Kakamega County to say that because the gubernatorial elections were cancelled on that day, my MCA votes have also been affected? Or, I mean, is it just the presidential election that the voter suppression argument is standing for? Or is it all? Because they are all separate elections. So how does one election affect the other? I think those are my questions for now. Thank you.
Thank you. Thank you, Chief Justice. Just a few questions. I think this could go to, I think, Mr. Orengo. You started us off with this elephant in the room, this 50% plus 1. And I've read the submissions, I've read the affidavits. There is something still surrounding this question of voter turnout, the percentage. It's like the beginning of where the controversy is located. What is the relevance of the percentage of voter turnout to determining whether a candidate marshaled the magical number? And then back to Mr. Murgor, this staging. Again, I've been intrigued. I've been reading. If I understood you correctly, and if I understand the affidavits correctly, we are having this Form 34A. The original, which is filled, leaves the polling station to go to the National Talent Center by road, let's say, for ease of understanding. Its image leaves to go to the same destination, but this time by air. Somewhere along the line, in mid-air, the image is captured. And then all sorts of things are done before it is re-uploaded, which means, therefore, if you go to that captured image, which has been re-uploaded, you will find different content from what it had at the polling station. So, to determine whether that has actually taken place, you would have to go now to the tallying center and locate that one that left by road and compare. Is it possible that that capturing in mid-air also somehow magically changes the content of the one that left by road. Okay, just because I just want to understand. Then let's get back to the 4 commissioners, because this is serious. We were informed by, I think this must have been Mr. Nyamodi, quite graphically, that the 4 commissioners were allocated roles other than those for which they were appointed as commissioners. Some were heads of protocol, I think others were media, welfare. Interesting stuff here, allocating such roles to commissioners. Why didn't they protest? Is this chairperson we are dealing with such a terror that nobody can face him and tell him you can't do this? Because now what we are hearing, these are serious disclosures. Because you can imagine I being, but because I was annoyed by, not annoyed, upset by my friend Willis for having tried to compare. So I'm just wondering, why is it that very serious Kenyans did not seize that chance and protest to the Kenyan people that what we are being given, the roles we are being assigned, have nothing to do with tallying and verification and carrying out our constitutional mandate. I think this is tied to my colleague here, is why to the tail end? Because I'm sure the voter out there
get to give their submissions, and also the first respondents, who are the first 4 commissioners who are in support of the presidential election petition, who include Juliana Cherera, Irene Masit, Wanderi, as well as Justice Nyang'aya, who got to give their submissions yesterday evening, and therefore today we expect to get to see submissions from the Independent Electoral and Boundaries Commission, as well as the chair of Chebukati. And later on in the day, we also get submissions from William Ruto in regards to the presidential election petition that was filed by Raila Odinga and his running mate Martha Karua, alongside other petitions. And so far, we got to see that out of the 9 petitions that were filed, 7 were consolidated and 2 were struck out, with the 2 which included one that was filed by Moses Kuria and the other that had been filed by Reuben Kigame, therefore leaving about 7 petitions that were consolidated. And about all of the petitions that had been filed by the 7 petitioners were heard yesterday, and key issues emerging from this were tied to the 9 issues which the 7-judge bench of the Supreme Court got to say that it's going to focus on during the hearing. Some of the issues that came out yesterday were, one of them raised by most of the petitioners, were but the person who was declared as the president-elect, who is William Ruto, did not get the 50% plus 1 as required by the Constitution. And most of them were saying that the election process did not meet the requirements of Article 81 of the Constitution for a free and fair election as required by the Constitution. That is just one of the lawyers working in representing one of the petitioners, who is Raila Odinga and Martha Karua, Philip Murgor, just walking into the hall where the hearing is going on. And now we're seeing another lawyer representing Kenya Kwanza walking in, who is Kithure Kindiki, who was also one of the chief agents of the Kenya Kwanza coalition during the presidential election petition. During the election, the general election that just concluded, as I was saying, that some of the issues that came out yesterday is that they were saying that William Ruto, who was declared as the president-elect, did not attain the 50% plus 1 requirement, and also the election did not meet Article 81, the requirements of Article 81 of the Constitution for a free and fair and transparent election. And also we got to see that they were saying that Regulation 87 of the Elections Act should be considered unconstitutional since it's not consistent with the Constitution, getting to cite Article 138(3)(c) of the Constitution, as well as Article 138(10), saying that Article 138(3)(c) of the Constitution calls upon the Commission in consultation to all of them are supposed to tally and verify the results before they're declared, and also Article 138(10) of the Constitution then
also wants to know. So let me leave it at that.
Thank you, Honorable President. I have a few questions, and the first one would refer to the lead petitioner, or rather the main petitioner, the first petitioner, if I may say, in the lead file, which actually initially was petition number 5, E005, Raila, Odinga, and Martha Karua versus the respondents. And later on, after consolidation, it became the lead file and file number 1. I'm concerned with the reliefs that are sought, the alternative relief sought. The first relief relates to the issue of scrutiny, which is ongoing, and the issue of the threshold, constitutional threshold of 50+1. And after the inquiry, you would like that after the scrutiny, election, and the inquiry on the election technology, all the claims which have been made, and that after there should be nullification of the results, and then an exercise of recount, and after the recount and tally, that the chair be directed to declare the petitioners as the petitioners. That's the two petitioners, Raila and Martha Karua, to be the successful, or to be the winners of the elections. That's one of the. So I was saying that we would like you to lay a basis, legal basis for this in your rejoinder. No remedy that has been pleaded is going to be taken casually. Every pleading, every relief that we have sought, we are taking it seriously as a court. Therefore, because you will not just do it cosmetically, you must be meaning it. So, is this doable? Is this feasible in law and in all other practical ways? We want justification, and from, I think even suggestions were there in 2017, but now we are here. So I would like you to firm up that and give us justify the legal basis, the constitutional basis of that, and whether lawfully, constitutionally, that is possible. Of course, we'll be coming to the issue of the capacity, after all the allegations, the capacity of that chair carrying out to be in charge of the exercise of the next process, if you are successful. But before that, okay, there's the alternative that if that's not workable, then a fresh elections take place. Now, that's the problem I'm having is that, and if an election is to be ordered to be done now, yet one of the reliefs you are seeking is that the chair and substantially the commission, but effectively the chair, you want us to hold him or to declare that he is not fit to hold public office because of his malfeasance, because of his the illegalities, irregularities, even allegations of fraud that he has perpetrated, that is not fit to carry out that exercise, to be in charge of such elections. Our Constitution, I believe, has never contemplated and envisaged such a serious situation, such a lacuna. And you know, we are all peaceful, loving people. We believe in the rule of law. We believe in constitutionalism. How is that possible? What are your proposals practically on the ground? If suppose this was done, how do you want us to navigate and apply the law Is that possible within the law? These are serious issues. These are serious remedies you're asking for. In the meantime, what is the de facto state? What is the status quo? Is that underpinned under the law? These are the questions that we would like to ask, because as you know, in Kenya we have never had a state of emergency, and we all never contemplated, and I don't wish to think about it. Finally, yeah, actually that is all, because the other questions have been asked quite exhaustively by my colleagues. Thank you.
Thank you, Judge President. The challenge one faces when they talk about the same subject at the end of a conversation by many people is that they find themselves repeating issues. But I will still ask what I had noted down during the proceedings, and you can choose the manner in which you will answer them. For Team Orengo, my concern is, and actually for everyone who has spoken about the Commission, what we have had that dysfunctional, what corrective measures were attempted, if any, and with what result? My second concern is from 34A. Minor Kiai told us that this election is done not at Bomas, but at the polling station. And for the presidential election, the return of that form is first by electronic transmission. And so, the way I understand it is that a photo would be taken of the form at the polling station. A photo. I want you to tell me whether it's called a photo or what it is called. Is it called a photo? Is it called an image? Is it called what? That's the question I'm asking. And so that time when it is taken, and as it is being sent originally, is it in PDF form? So the journey, because this has to be understood, the journey from the polling station to Bomas, the things that happen in between must be described by the nature of that image at the original place, at the starting point. My other concern, which ought to have followed the first one before this PDF language, is what is to be done as a corrective measure against the chair of this dysfunctional commission. And is it to ignore the constitutional procedures and safeguards that are already in place? My final concern is concerning the relief to declare. What I have heard since morning, because of the dysfunctionality of the commission and a few other things, is that nearly everything about Articles 81, 86, the Act, have been impugned. In fact, one of you told us that everything that would possibly go wrong went wrong. So if every process that was undertaken in this process has so far been impugned, are we nevertheless to declare a winner? Are the figures, in the event that we arrive at figures that show that either the current president-elect has more votes than others, and or the petitioner in petition number 5, in fact, has more numbers, what are we to do? Are we still to declare? Irrespective of all the other processes having been impugned as you have submitted to us today. If you assist me with some direction in those issues, I shall be in a position to deal with the petitioner's case. We'll see what we will do with the respondents when their time comes. Thank you, Judge President.
Thank you. I think all the questions I had have been asked, but I'd just like to follow up on what Justice Ibrahim asked. The team on the read petition, they have been called Team Senior Counsel Orengo. You have asked us to find the chairman culpable of various breaches of the Constitution. And as Judge Ibrahim explained, you have even told us to find that he cannot. Should we find that there should be a repeat election, he cannot preside. My dilemma is, this is a Constitution Office order, under Article 251(2) of the Constitution, there is a detailed procedure that is provided for the removal of a constitutional office order. And what I would like you to address us is, how do we go about that? Would we be making an order that is contrary to the Constitution? Because like the judge was explaining, we are a country that believes in the rule of law, in the right of a person to have a reply, to be tried. So, you know, for the breaches that EOC has committed. Mm-hmm. And that is also related to the issues you have also cited about criminal culpability. I want you to address us on, because we have an Election Offences Act, so that if somebody has committed an election offense, they ought to have been charged and tried before the court with the jurisdiction. In this case, I know we gazetted some magistrates to deal with election offenses, and my question is whether we wouldn't be usurping the powers of the magistrates if we have to make any order regarding election offenses. Then to the team led by Senior Counsel Mr. Mwite for the 4 commissioners, I still want to understand at what point the commission ceased to function as a corporate entity. Is it when the 27 constituencies were not announced? Or is it when, I am really trying to understand that, because we saw them announce regularly the results at the plenary in Bomas. We really want to understand, like the Vice President is asking, when did the Commission become so dysfunctional? We really want to understand that. Is there a stage where they were working together in tallying and verifying, and then they went and announced, and then suddenly there was a stoppage because the announcements also stopped streaming live? So we really want to understand that. Then my last clarification will go to Mr. Kibe Mungai. And I want you to answer this and tell us how you know that IEBC did not make arrangements for certain categories of people to vote, especially the IEBC staff. How do you know they did not vote first before they started the exercise? Because they were in a polling station, they could have transferred their votes to the station where they were conducting the exercise and voted. You know, because this seems quite subjective, so you needed to explain more that you know 700,000 people did not vote because IEBC did not make arrangements. I think those will be my questions or clarifications that I will be seeking from Council.
Justice, I have one follow-up. May I piggyback on your last question? Section 6 of the IEBC Act, 6.1, says that the chairperson of the Commission shall be a person who is qualified to hold the office of Judge of the Supreme Court under the Constitution. Then 7A says that the chairperson or member of the Commission the office shall become vacant if the holder dies, resigns from office by notice writing to the President, or is removed from office under Chapter 6 or Article 251. In that context, if perchance we were to order removal of Chebukati as chairman, would the Commission still be intact with the remaining 6 commissioners without a chairman of that qualification? I'm just wondering for my own sake. Thank you very much, Your Justice.
I think that brings us to the end of today's proceedings. It was a long day.
Information, Madam Chief Justice. There is still an issue arising out of the scrutiny. I am told I would like my learned junior to explain, because he's the one covering the technical issue of the scrutiny.
Good evening, my lady, the Chief Justice, and the Honorable Judges of the Supreme Court. My name is Eric Gumbo. We've had interaction with my colleagues who are handling the scrutiny, and they give us the indication that there's been very good progress so far, but there's one specific issue which they would want to get clarification from this court on, that arises from Order Number 2. Specifically, the use of the word forensic image. Now, the applicants appear to be interpreting that to mean an opportunity to get the image of the entire server. Now, that is causing a bit of a concern, because then it means if they have the image of a server, technically, they'll have gotten access to everything that certainly is contained in that server. It means that that order will be so far-reaching that after that event, it may not be possible for the IEBC to use that server again. It then particularly concerns the Commission because if perchance there was an order for a repeat election and you don't have that infrastructure, it then means that that election may not be conducted. The other concern is the potential breaches that might be in relation to third-party licenses that are contained, and so therefore it really is important that we get clarity on that question so that then the exercise can proceed smoothly. I am most obliged.
Yes, with your permission, Madam Chief Justice, ladies. I raise because after we broke off over lunchtime, I personally went to the IEBC offices on the first floor where the exercise was going on. And I'm sorry, but I don't think what my learned friend has said is exactly what was going on. First, the team that was sent by this court to supervise did come up with what was an implementation matrix and laid it out. I think this was done yesterday. And what I learned is the biggest problem that has been going the whole day are arguments about this implementation matrix. And as by the time I left at 3 o'clock, nothing had happened. And even some of the simplest issues as giving copies of the technology system security policy had not happened. So what I met is an argument between technical computer people about what they should comply or not comply with, about what forensically, for instance, the issue of the forensic image is not correct that the demand was for an image of the entire server. In fact, what I meant had been agreed on was that the part of the server that was supposed to be forensically imaged was going to be cloned so that there's no access to and that had also been agreed on. But when it came to implementing it, there were always new arguments. And in my estimation, what I found...
Everybody, ladies and gentlemen, welcome to today's proceedings. I'm looking at the consolidated petition. We had hoped to hear IEBC first. IEBC and the chairman and the other two commissioners. Just a minute, Fro. It looks like...
Your Ladyship, members of the court, before my learned friend takes the position, perhaps with the permission of the court and with the permission of my senior James Orengo, I would like to bring certain concerns of the first and second petitioners to the court regarding the ongoing scrutiny. With every passing second, of course, time is lost. It is still with regard to what we consider the non-compliance with order number 2 regarding access to the servers. I wish to report, as of this morning, nothing has changed. IEBC continue to refuse to provide the forensic image of all 8 servers. Your Ladyship, my lords, the 8, we've been using the word servers in plural, but I would like to refer to the affidavit of Mr. George Njoroge at page 11, which gives the name or identity of the 8 servers. Page 11 of the forensic report by George Njoroge, which gives the particulars of all 8 servers. Of those 8 servers, IEBC are providing only limited access to server number 5. I have mentioned with every passing second, an opportunity for the court and ourselves is being lost. With the limited access provided yesterday to server number 5, our team were able to observe a large number of deletions. So we suspect and we are concerned that the delay on the part of IEBC is to delete vital data, and when finally time runs out, not to provide the information that we require or provide logs that have no use to anybody. So we are requesting that the court direct further that access, forensic access, be provided to all 8 servers, together with copies of logs for all 8 servers. I am further advised that the question of the forensic imaging is the one that takes time. It takes hours. It takes hours. So that needs to be given, that direction or that order needs to be given right away. In the alternative, perhaps this is the moment when the court considers extending time so that IEBC do not do what they are good at doing, not providing or providing when it is too late. So that is all I wish to mention at this stage, and I would like that the court addresses it before we start the day. Thank you.
Thank Mr. Gumbo.
A question?
Good morning, my lords and my ladies. My name is Eric Gumbo, once again. Let me start from saying that I think I'm quite perturbed by remarks from my learned senior counsel when he says that IEBC is not complying with the court order. That certainly is an inaccurate reporting. I think the most important thing would be to get an accurate and objective position in relation to this matter. It cannot be, because we've seen tweets, we've seen a lot of social media activity in the night, which is not accurate. And I think whatever was happening was that report was meant to be for this court. It wasn't meant to be discussed in social media. And I think there was already guidance on that. So even this narrative that is being propagated certainly is not for this court. And I think we take exception to that. But back to the critical issue, yesterday we did give an indication that whereas the order of the court was that the IEBC was to give a supervised access to the servers, that was then interpreted by the applicants to mean that they would get a copy of the whole server. We then expressed concerns with what that would mean, and we asked that the court then gives guidance so that as we proceed, there's clarity. That is really what we had hoped that we would get this morning to enable us resolve the matter. Certainly, it is not to take away the server from IEBC. I'm most obliged.
Thank you very much. On behalf of the court, may I say this? That issue was discussed by the full court this morning. We received a full report from our technical team that was leading the exercise at IEBC, and we received a message soon thereafter from the team to say the process is heading to completion. So that as far as our team is concerned, the process at the IEBC is finished. The process at Forodha House is coming to an end shortly. And so the court has then asked me to express, in anticipation of this question, that should there be any issues left unattended to or any concerns that parties have, let those issues be addressed when you receive the report later this morning. You can address the question of what you're calling non-compliance. You can address the question of what servers you think were not accessed. You can address the question of the information that you received, your agents were there, and you, IEBC, can respond to say, what are your answers to the complaints by the petitioners' advocates, and then the court will ultimately determine what is the import of all the things you're saying. That report was meant for the court to make a decision on the issues you raised. So as far as we are concerned, that matter is spent. Please address us tomorrow substantively on each of the questions once you see the report, which is actually being prepared right now. That's all I have been informed to tell you by the court. I thank you, CJ. I thank you, Counsel.
Madam Chief Justice and the Honorable...
Sorry, Senior Counsel. I think, CJ, allow me to say this. As much as possible, let us do matters within this court. I think the debate out there is convoluting matters. And when we see documents being circulated outside the court, it only just inflames the public. Let us please keep matters right here. Let's manage our issues right here until we finish. That's all I'm saying in answer to Mr. Gumbo's concerns. But as far as the court is concerned, we're on top of things. I thank you.
Madam Chief Justice and the Honorable learned members of the court, I am Githu Muigai, and I appear for the IEBC, for its chairman, Wafula Chebukati, and for Commissioner Professor Abdi Yakub Gulei and Boya Molu. I am assisted in the defense of this gentleman and the institution by Kamau Karori, Senior Counsel, Abdikadir Hussein Mohammed, Senior Counsel, Mr. Eric Gumbo, Mr. Mahat Somane, Dr. Willie Mutumbwa, and Mr. Peter Wanyama. I would like to request you, Madam Chief Justice, if you could kindly confirm that our combined team has 4 hours, our 3 hours plus the 1 hour between the 2 commissioners who are represented by our team.
That is not correct, Prof. The 2 commissioners have 30 minutes. You remember the other 4 commissioners and 15 minutes each. They had 1 hour among the 4 of them. So you have 3.5 hours.
I'm guided by you, my lady, and I have changed that to 3.5 hours. Thank you. We have filed before you a wide range of documentation, which in our very humble view is very, very comprehensive. We draw your attention, honorable members of the court, the responses on behalf of the chairperson and IEBC, the affidavit of Wafula Chebukati, the affidavit of Marjan Hussein Marjan, the CEO, the affidavit of Professor Abdu Yakub Gulei, the affidavit of Commissioner Moya Mulu, the affidavit of Martin Washira Nyaga, the database administrator, the affidavit of Michael Uma, the director of ICT, the affidavit of Moses Lendema Senkuli, the acting director of voter registration, and affidavits filed by presiding officers and residing officers of the contested polling stations and constituencies. Let me start, my lady Chief Justice, by observing the peculiar nature of the proceedings before this court. That is to say, these are proceedings that are based on affidavit evidence. And we all appreciate the limitations that has. That we have persons who have sworn affidavits who are not available to court to be cross-examined on their allegations. And some of the allegations we have had, as we shall demonstrate in the course of our submissions, are outrageous, to say the least. My lords and ladies, we have been here before you. Some of us have had the great privilege of being here before you in 2013, in 2017, twice. And this honorable court must take credit, I think, unparalleled in anywhere in the Commonwealth, in my humble learning of the subject, in helping to clarify how the electoral process in Kenya should be conducted. And we submit that the clarifications that this court has given since 2013 have enriched the conduct of the electoral process. And it is my first submission that the IEBC and its chairman conducted the 9th August 2022 presidential elections strictly in compliance with the guidelines that this court has given. My lords, since the annulment of the presidential election in 2017, IEBC overhauled its entire electoral process procedures to align those procedures with the guidelines that my lords had given. Your decision in the minor care, the decision of the Court of Appeal in the minor care case set out the guidelines for the protection of the ballot at the polling station, the transmission, tallying, and declaration of presidential results. We have abided by that decision. Your decision, my lords, in Raila Odinga versus IEBC petition number 1 of 2017 rendered even more detailed clarifications on the procedure. The decision, National Super Alliance, complementary, used that in this election. Since 2017, over the last 5 years, the IEBC undertook post-election evaluation. It reviewed its strategic plan. It developed an elections operations plan, a boundaries review operations plan, continuous registration of voters, and several other measures that flowed from the guidance that this court had given. My ladies and my lords, in the cases that have brought us before you previously, we had numerous arguments about jurisprudence. What does the law mean? What do the regulations mean? What does the Act say? The petition now before you has absolutely nothing to do with any legal lacuna, because you have spoken so loudly on that subject previously. Although my learned friend, Mr. Karori, will be reiterating what you have said as regards Article 183, your own thoughts on the subject are very well laid out in your previous judgment. This, my lord, is a petition about facts. It's a petition about what happened. What happened, when, where, with what consequences. And therefore, ultimately, notwithstanding the very lucid and learned and honest arguments by my very learned friends to my right, this petition is about numbers. It is ultimately about numbers. The petitioners have tried to argue every other point except numbers. I will be demonstrating to you, my lady, my lords, in a short while, that we conducted a proper, fair, constitutional, legal, impartial election. My learned friend, Mr. Kamau Karori, will follow me, and he will get back to the parameters that you have set. Mr. Eric Gumbo will talk about, that's Mr. Karori will answer, and this is very important, my lords. We do not want to waste our 3 hours perambulating around every conceivable issue in this petition. We will be answering the questions you asked us. Mr. Kamau Karori will answer question 4, 6, and 8. And that will be a submission about the electoral process. My learned colleague, Eric Gumbo, will answer question 1, 2, and 3, and that's about the technology. My learned friend, Mr. Mahat Somane, will answer question 4, 3, 4, 5, 7, and 8. And I do not want to belittle the rest of our effort, but that is the man who will explain that numbers don't lie, that numbers speak for themselves. Mr. Abdikadir Mohammed, Senior Counsel, will address you on the burden of proof and the standard of proof and whether the reliefs sought by the petitioners can be granted in this matter. If we still have time, as we hope we shall, Dr. Mutumbwa and Peter Wanyama will address you on this issue that seems to be in the fridges, but in our view, totally inconsequential, of the KPMG report and the alleged problems with the voter registrar. Let me start by saying, my lords, you have been urged by several counsel who have spoken before me to find that this election was irretrievably flawed. That from the word go, one counsel said, and I quote, everything that could go wrong went wrong. If that be true, and we deny that that is true, then it would mean that everything from voter registration, voter education, procurement, nomination, voting, counting, tallying, verification, and declaration was totally flawed. What would be the consequence of that? First of all, and I say this with the most tremendous respect, first of all, you have been addressed by counsel of great eminence, including my learned senior, James Orengo, my learned junior, Professor Tom Ojienda. In this court, my lords, as we sit here this morning, there are no less than 3 governors addressing you elected under this election. There are no less than 4 senators elected under this election. And there are no less than 4 members of parliament elected under this election. When, my lords, it is not in my place to suggest the questions you should put to counsel, but I would plead with you to put that question to counsel when they return to the podium. Are they happy with their own election? If they are, how then is it that this election is irredeemably flawed? I suggest with tremendous respect that that is the use of hyperbole. This election was conducted, as most international observers observed, it was the fairest. All observers came back with one conclusion. This was an open, transparent election. Was it a perfect election? No, because there is nothing like a perfect election. This is an election conducted by human beings, and there are human errors within the electoral process. Were the few errors that are admitted by IEBC of a magnitude to allow this court to set aside the election? It is our humble submission that the answer is no. It has not been demonstrated, and my learned friend, Mr. Abdi Kadir, will deal with that matter. Let me point out to you, my lords, that this is one of the few petitions that this court has seen that is full of generalities, innuendos, hypothecations. Yeah. We believe there was one counsel who repeated several times, our theory is, our take is, our understanding is, not evidence, nothing of probative value, speculation, generalization. It is our very humble submission that framed in those general speculative terms, lacking clear, cogent, probable evidence, these petitions lack merit. It is made worse, my ladies and my lords, by the fact that the petitions make grave allegations of a criminal nature: fraud, tampering with election materials and results, conspiracy to unlawfully influence an election outcome, and even implied treason. Implied treason. All that without a shred of evidence. All that without a shred of evidence, especially as it relates to the Honorable Chebukati, the chairman of the commission. The vilification against this gentleman goes beyond anything we have ever had before in this courthouse. It was personalized, it was vindictive, it intended to lower his standing in our community and within the legal profession. It was unwarranted. I have had occasion again to defend Mr. Chebukati, although he was not my client. I was in a different office. But I recall mentioning in 2017 before your lordships that this gentleman was being vilified for doing exactly what the minor Kiai court told him to do. It told him, don't touch the results coming out of the polling station. That is the final result. We then came here to this court and he was called all manner of names at that time. This has not stopped. What should we learn from this? We should learn one thing, and it is a very unhappy lesson. The attack on the chairpersons of the commission has a long history. There was Justice Zacchaeus Chesoni, there was Samuel Kivuitu, there was Isaac Hassan, and now there is Chebukati. The pattern is the same. The pattern is the same. None of them has been allowed to leave office without vilification and a vindictive process being engineered against them. I don't want to go to the details because we all know the details. We remember the details. So what is wrong? There is nothing wrong with IEBC. There is nothing wrong with Wafula Chebukati. There is something very wrong. There is something very wrong in the way the persons who participate in the electoral process accept winning or losing. That's the problem. At an appropriate time, when all this is over, I entertain no doubt that an independent group of people looking at the work that Mr. Wafula Chebukati has done for our nation will recognize him as one of our outstanding heroes in the history of our nation. Thirdly, I want to say that the evidentiary material, which will be addressed by my colleagues, is of such a character that it falls way below the standard you set in petition number 1 of 2017. And since I don't want to take too much time, I'll leave that for that purpose. To return to this issue, that this court, in our very humble view, needs, and I'm very sure from the questions the court has asked so far, that the court appreciates very deeply, and that any order has consequences, and those consequences must be consequences that can be contained in our democratic and constitutional process. The Supreme Court cannot act in vain. It cannot act so as that the judgment should read like a learned legal article. The Supreme Court always acts so that it can defend democracy and the rule of law and constitutionalism in a practical and enforceable way. So if this election is so badly flawed as you are invited to find, then this court would have to find that every MCA, every MP, and every senator, and every governor was not properly elected, and the whole of the government of the Republic of Kenya should be reconstituted afresh. I don't know whether my learned colleagues have contemplated the consequence of what they have requested. My client, Mr. Wafula Chebukati, is a man who enjoys constitutional protection of his tenure. Why did the Constitution protect him? Not him alone, the chairman of independent commissions, for precisely this form of witch hunting. The Constitution cannot countenance that a constitutional office holder is to be witch hunted in the manner suggested here. That he walked out of his office and took the phone many times, then came down and sat down and did not consult the people who were having tea. A whole lot of irrelevant material that cannot be the basis of interfering with the independence in section 163 of Mr. Wafula Chebukati. It is said that he should be removed from office and forbidden from ever holding public office. And I want to ask my learned colleagues for the petitioners, is that really a serious submission when the Constitution itself contains complex processes of the removal of a person? He is now to be removed here by reference to affidavits of hearsay on the back of hearsay? I do not think it is a serious submission, and I invite my lords not to act on it at all. Two final points before I invite my learned colleagues. My very able senior learned friend, Paul Muite, said that the commission is the majority of the commissioners. That cannot be a meaning of the commission that arises from the Constitution. The Constitution contemplates that the word commission will be used in multiple senses. The returning officer, when he makes a declaration, is the commission. The officers of the commission, when they procure, let us take procurement, When the procurement process is done by officers of the commission, that is the commission. When the chairman declares the presidential vote, he is the commission. There are multiple senses in which the Constitution uses the commission. It does not intend that the commission is to be used as sitting in plenary and voting, because very little of the commission's work involves voting. I believe that if we cure that misunderstanding of the commission, the rest will follow. It will be quite clear that Wafula Chebukati was acting as the commission in the manner defined by the Constitution at that point. Because it is a body corporate, and that has already been spoken to. Let us come to this last point about how did the commission break apart? Again, I don't want to belabor this point because the learned court itself has raised this issue. We have an election conducted up to the 11th and a half hour, and everybody is on board. Everybody is on board. The public can see them declaring the results. What is this that happens within the half hour? The affidavits speak for itself, for themselves rather. And my learned colleague will take you into the detail. The affidavit speaks to themselves. There is a concerted effort. There is a concerted effort, external, to ensure that the process comes to an end without a declaration. So the sanctimonious, self-righteous, pompous pontification of the so-called 4 commissioners are an afterthought. They are a complete and total afterthought. And should be seen as that. One shudders to contemplate what would have happened constitutionally. So there is no, the election is not called. The deadline is the following day. It is not called. We then go into an uncharted waters. Totally uncharted waters. We have a caretaker government in place that is hamstrung in what it can do. We cannot set up a new government because an election was not declared. We cannot call a fresh election. I shudder to think what would have happened. I'm sure the court would share the same concern. And I want to say this before I sit down, my ladies and my lords. Integrity is not numbers. Integrity is not numbers. And that's why the great statesman said, I protest. I protest even if I do so alone. To do the right thing does not require you to be with the majority. It requires you to be with your conscience. I invite Mr. Kamau Karoli to address you on the issue of 183, and I thank you.
Senior Counsel, before maybe you see it, we have received information that your side is going to present 2 videos and a PowerPoint presentation. The first video will take 4 minutes, the second video 14 seconds, and a PowerPoint presentation, which has 28 slides. We don't know how long it will take, but just to warn you that that is within your time.
Most
Your
obliged.
time will be taken into consideration.
Most
We will not lose time like we did yesterday. We are very keen.
Most obliged, my lady.
May I please, my lady, the Chief Justice and judges of this court, and good morning. My lady and my lords, I will be addressing you on mainly on the issues surrounding Article 138 of the Constitution. And my ladies and my lords, the reason why we are starting from there, and which is right about where my learned senior left it off, is that there are many allegations that have been made in this petition. In fact, that seems to be the main issue surrounding these petitions, regarding the manner in which the functions set out in Article 138.3 and 138.10 were conducted. One of the allegations that has been made is the chairman unilaterally tallied, verified, and declared the results of the presidential elections, that there was a requirement for a complete corporate process of internal tallying and approval by the commissioners, and that the chairperson can only act with the concurrence of the commissioners. Now, it's my submission that the reason why these submissions are being made is based on a confusion that stems from a misunderstanding of the nature and character of the commission and the interplay between the commission, the functions bestowed on the commission, and those cast upon the chairman of the commission. So first of all, the question that comes up is, who is the commission? And my learned friend, Senior, has alluded to it briefly, but let me just make this distinction because it is important. The commission, IEBC commission, is established like all the other independent commissions under the provisions of Article 250 of the Constitution. But more importantly, and this is the distinction that I think is important to draw, if you look at what Article 250 talks about, 251 says each commission shall consist of at least 3 but not more than 9 members. The next one says the chairperson and each member of a commission, so that these commissioners are members of the commission, they are not the commission. So that where the law refers to the commission, it is not referring to the commissioners, but it is referring to the body corporate that my learned senior referred to, and which is established or under the provisions of Article 253 of the Constitution, which says that each commission is a body corporate with perpetual succession and a seal. So where in Article 138 reference is made to the commission, it is that body corporate that is referred to. And this is amplified by the provisions of Sections 11 of the IEBC Act. My lords and my ladies, Section 11.2 of the Act establishes the Secretariat and the Commission, so that the Commission consists of the commissioners, the chairman and the commissioners, and the Secretariat. Then 11.2a defines who the Secretariat is as such professional, technical, and administrative officers and support staff as may be appointed by the Commission in the discharge of its functions under this Act. And B, very critical also, such public officers as may be seconded to the Commission upon its request. This is what comprises the Commission. And then, what is the role that the commissioners are supposed to play? Well, Section 11A of the IEBC Act then says that the chairperson and members of the commission, again members of the commission, shall perform their functions in accordance with the Constitution, and in particular, shall be responsible for the formulation of policy and strategy of the commission and oversight. Those are the 3 roles that are specified in the statute: provide or formulate policy, strategy, and oversight. That is the role that they play. Then the Secretariat shall perform the day-to-day administrative functions of the Commission and implement the policies and strategies formulated by the Commission. So this then brings me to the provisions of Article 138, 3C, which is at play in these petitions. And it's important, my lords and my ladies, to read what the provisions of that section say. And the reason why I go straight to that provision is because the petitioners are using that provision to say that the provision requires the commissioners to be involved in the process of tallying, verifying, and declaration of the results. But what 138.3c says is that in a presidential election, after counting the votes, these are the words they leave out, after counting the votes in the polling stations. This is about the polling stations. In the polling station, the Independent Electoral and Boundaries Commission shall tally and verify the count and declare the result. So this section refers to what happens at the polling station. My lords and my ladies, there are over 40,000 polling stations in Kenya. It is not conceivable that the 7 commissioners, including the chairman, would be the one to conduct the business of tallying, verifying the results, the votes at the polling station. This activity, as has been acknowledged by the courts in many cases, is undertaken by the officers of the commission in those areas. Indeed, in the first petition in Raila Odinga 2017, Lords, the court at paragraph 287 says, the duty to verify in Article 138, which I've just referred to, is placed squarely upon the Independent Electoral and Boundaries Commission, which was the first respondent. It is exercised by the various agents or officers of the first respondent. That is to say, the presiding officer at a polling station, the returning officer at the constituency level, and the chair at the National Tallying Center. No reference here to members of the commission. And this is very deliberate. The process of conducting an election is a statutory process. It is set out in statute. It is not an issue that is left to determination by the commissioners in a meeting of plenary as they have suggested. And so, my lords, the assumption by the petitioners that the commission refers to the commission is wrong and belies the case that has been brought before you. And so, my lords, the next issue that I want to deal with is the question of the role of the commission versus the role of the chairperson. My lords, under Article 138.3c, as I've said, the role of the commission, not the commissioners, is just to tally and verify the results. Sorry, and what is important here is this. My lords, and to respond maybe to my learned senior John Mohammed, the results of the vote at the polling station are made on the same day. The decision as to who members or the electorate will elect is made at the polling station, and the outcome of the voting is determined on the same day. It is filled in Form 34A. It is pasted on the doors of each and every polling station. Now, the important thing here is that there is not a single affidavit or evidence that has been placed before you by anybody who says that the results that were pasted on the doors of every polling station, the Form 34A, is different from the ones that were announced or declared by the chairperson at the National Tallying Center. And this brings us to what the courts have said consistently, that the results as announced by the presiding officers at the polling stations are final. Once those results have been declared, the voter knows that in my polling station, which had a maximum of 700 voters, the outcome of that vote was this candidate A got so many votes, candidate B got so many votes, and so on. So the result is known after the close of voting, when the counts are tallied by the presiding officers. And then, my lords, there is Article 138.10, which places an obligation on the chairperson to, within 7 days after the presidential election, to declare the result of the election. Now, my lords and my ladies, there is nothing strange about the provisions of Article 138.10. Declaration of the result, as was held in the Joho case, declaration of result is done in 3 stages. The first declaration is done at the polling station. If the argument by the commissioners was correct that the declaration requires to be approved, it would then mean that even the result that is declared at the polling station would require the consent of the commissioners. It would mean that the results declared at the constituency tallying center would require the consent or approval of the commissioners. It would mean that the results declared at the county tallying center would require the participation consent of the commissioners. That would introduce what this court has been avoiding all along, which is human interference with the process of tallying, verifying, and declaring results. And my lords, I'll just discuss a few cases that show why these considerations are important, and I'll start with the case of Maina Kiai. My lords, in that case, the court stated that, sorry, my lord, let me start with the Raila Odinga versus IEBC, the 2017 decision. At paragraph 287, it says, the duty to verify in Article 138 is squarely placed upon the IEBC, and this duty runs all the way from the polling station to the constituency level and finally to the National Tallying Center. There is no disjuncture in the performance of the duty to verify. It's exercised by various agents, that is to say the presiding officer at the polling station, the returning officer at the constituency level, and the chair at the National Tallying Center. Nowhere in that decision do you hear reference to members of the commission. It refers to specific officers whose duty it is to verify and declare the results. And why is this critical? At paragraph 288, this court explains why this is important. And it says, the simultaneous electronic transmission, and my learned friend will talk about the electronic transmission. Paragraph 288, the verification process at all these levels is elaborately provided for in the Election Act and regulations. I will jump up to the part which starts by saying, but this electronic transmission also acts an insurance against potential electoral fraud by eliminating human intervention, intermeddling in the results tallying chain. Now you are being told that the commissioners need to be involved in the process of verifying and declaration of the result. This introduces exactly what the court said. We do not want human intervention or intermeddling in the chain of result declaration. And this ensures that there is no variance between the declared results and the transmitted ones. Now, the chair, again, plays a critical role in this whole process. In paragraph 365 of the same judgment, this court said that the chair has the duty of receiving the Form 34A as received from the constituency returning officers by signing the taking over section of Form 34B. It is his duty to do so. And then, my lords and my ladies, I deal with the issue that was raised that said that the chairperson styled himself to be the returning officer in respect of the presidential elections, and the suggestion that was made is that this title does not exist. First, my lords and my ladies, this is it's wrong. That's not the correct position. The chairperson undertakes the role of declaring results, which is a role that you'll find under the under the Elections Act, is a role reserved for a returning officer. But just to lay this whole issue to rest, my lords and my ladies, in the case of Raila Odinga versus the Law Society of Kenya, this is the first Raila Odinga 1, 2017, at paragraph 8, this is what this court said. It says, the second respondent, who is the chairperson, Independent Electoral and Boundaries Commission, that's the second respondent. The second respondent, comma, the chairperson of the IEBC, who is the returning officer for the presidential election. Even this court recognized that is the role he plays. So it is not himself who styled himself. even this court recognized that role and says it's constitutionally mandated under Article 3810 of the Constitution of Kenya to declare the result of the presidential election and deliver a written notification of the result to the Chief Justice and the incumbent president. So that the role of the chairperson in the declaration of the results is recognized both under the Constitution, Article 3810, but this court also specified that in playing that role, essentially what he's doing, he's playing the role of a returning officer. But this was even emphasized further in the clarification decision that was rendered by this court in 2017, and at paragraph 61 of the majority, the decision by the majority, the court said that at paragraph 61, it says that the, it talks of, it's a long sentence, but my lords and my ladies, I just want to read what is critical. It says the constituency returning officer aggregates Form 34A from the polling station into Form 34B before generating Form 34B. Doesn't the returning officer verify the figures in Form 34A? Is it not a fact that the second respondent, as the national returning officer, so that even in the clarification, when we came back to court and sought clarification, this court confirmed that in fact this gentleman is the returning officer, national returning officer, for purposes of the presidential election. And so the issue of him styling himself, my lords, does not arise. And it just shows you the levels to which the chairman has been unfairly vilified in a situation where the law is quite clear in the conduct of, on how he should conduct his affairs. The other thing that was also clarified a lot, my lords, and I'm just referring to this because there's no need for me to argue this, if the authorities already say so, is that the chairperson, the verification that is referred to in Article 138, 3C, this court said that the verification that is undertaken by the commission employees, by the people that we saw in the rotunda, in the tallying center, it says the first respondent on behalf of the second respondent, commission employees on behalf of the chairperson, must verify the results against those in the transmitted Form 34A. So that the way the petitioners have put it is completely the other way around. They are suggesting that the chairperson is the one who undertakes activities on behalf of the commissioners. It's actually the other way around. It is the commission employees that undertake the verification process on behalf of the chairman to enable him declare the outcome of the results. Which takes me, my lords and my ladies, to the next issue that I want to cover, which is the declaration of the result a plenary decision? And the question that we must start with is, what is the decision that needed to be made at the National Tallying Center? What is the decision? And my lords, if you look at the architecture of Article 138 of the Constitution, and you look at the Elections Act, there is absolutely no decision that is supposed to be made at the National Tallying Center. None. The only thing that's supposed to be done is an arithmetic exercise, which is tallying, aggregating the results, verify that the form that has been brought by the constituency returning officers, Form 34A, the original, compares or is the same as that which was transmitted electronically. Then add up the numbers. And then the chairperson is supposed to determine whether the threshold in Article 138(4) has been met, which is, has the person met the 50% plus 1 threshold? It's a question of arithmetic, which the chairman must make. And lastly, make a declaration whether there is somebody who has been validly elected. Fill the forms, and that is the end. That is the end of the exercise. He then gives the Form 34D to the president-elect, and that brings to an end the election process in respect of the president. The other administrative steps of giving the certificate to the Chief Justice and to the President comes later. Now, no one here is saying that there is this particular Form 34A that is different from the ones that were received. In fact, as my learned senior correctly says, nobody is saying that the number that was declared by the chairman is wrong, because according to us, the numbers achieved by the president-elect is different because they have calculated it. The number achieved by the second was a different number because they have calculated it. Nobody is talking numbers here. All that they are saying is trying to challenge the process that went on at the National Tallying Center. But nobody is saying that any particular number is wrong. And so, my lords and my ladies, the suggestion that we should have a plenary conversation about the result would one that would cause huge ramifications to this country. Because what would happen if after the elections have been conducted and completed, commissioners, for whatever reason, take different positions and decide that they are not agreed on the declaration to be made, and that a declaration cannot be made until they all agreed? If that was what was intended by the Constitution, nothing would have been easier for Article 138(10) to have made reference to members of the Commission. It is deliberate that it only required the chairperson to declare the results. And in my humble view, my humble submission, is that the protection intended by Article 138(10) of the Constitution worked in these circumstances. We got a declaration made because it is the obligation of the chairman to make that declaration, and anybody unhappy with that declaration, the option available to them is to come to the court, and the court will determine the issue. The option cannot be that a number of the commissioners can decide we are the majority and we are going to walk away, and therefore there will be no declaration of a result. That is capturing the Constitution. It is ensuring that the Constitution is not able to ensure the establishment of a government in accordance with its provisions. It is the reason why that obligation is cast on one person and one person only. And it is unfair to vilify Chebukati for doing what the Constitution told him to do, that if you are satisfied that the threshold in Article 138(4) has been met, and if you are satisfied that there is somebody who has been elected to be president, you need to make that declaration. Just like the declaration is made at the polling station, constituency level, county level, and at the presidential level. Lords, this then takes me to the question of, and I don't want to spend a lot of time here, I will just gloss through it. What is verifying and tallying? I don't think I need to define this. I think verifying, I've already said, is simply just comparing the transmitted, electronically transmitted Form 34A against the Form 34B, Form 34A original as brought by the returning officer from the constituencies against the ones which have been transmitted. That's the exercise that is called verification. Tallying is aggregating, it's adding up the numbers just to make sure that that has been done. And this exercise was carried out. And we'll show you by the videos that will be played that in fact, the members of the commission, the commissioners, were involved in the exercise that was being undertaken at the National Tallying Center. Now, my lords and my ladies, you are also referred to extensively to the regulations and to the Gazette notice. So let me say this first. This is the first time, my lords and my ladies, that I hear a person being criticized for being too open. The chairman informed the purpose of a Gazette notice to inform the general public. The chairman informed the general public that he is the returning officer for purposes of the presidential election. He didn't need to do it, yes, but he did it. And he is being criticized for that very act of informing the public that of this fact. Secondly, they are now saying that because of the forms being in the public portal, it was possible for those forms to be interfered with in some way, and we'll show that there was no such interference. But the criticism now is you are too transparent. You are just showing people things. Even your numbers, you are showing them. That is the complaint. And my lords and my ladies, this court has gone to great lengths to say that under Article 10, transparency is an essential ingredient of governance. So when you are being transparent by providing information, how can you be vilified for that? My lords, the chairperson is also criticized for setting out the result path at the National Tallying Center. He is telling the public, this is how we'll carry out the function of tallying and verifying. How can that be a source of criticism? Nobody is saying that there's a promise you made in the result path that was not followed. And my lords and my ladies, it's a humble submission that The process that was followed at the National Tallying Center, which is set out in the Gazette notice that I do not need to read out to you, was transparent, was verifiable, and was in accordance with the provisions of the Constitution. None of the agents that were involved and that signed the Form 34A has denied that they signed it. Nobody has come to challenge any particular document saying that it is not their document. And an interesting question was asked yesterday. How was a handwritten document to have been changed? In fact, by having it handwritten, it helps in ensuring that if there is any alteration, this is something that can be easily seen, because you can't change somebody's handwriting. My lords, as I leave this point, it is also important to note that the agents of the presidential candidates, all of them, all 4 presidential candidates, their agents were at the National Tallying Center on the day. All of them. They participated in the process of tallying and verification. None of them has sworn an affidavit saying any of the numbers that were being, or the exercise that was being undertaken was wrong. None of them has picked a document, and they were allowed to take copies of all the documents. They were allowed to take images. None of them has complained about that process. Then we go to the issue of the 27 constituencies, and this makes me feel very sad, because, my lords and my ladies, as this process was going on the 15th of August, at about 3 o'clock, the whole exercise of tallying and verifying had been completed, and that is in the affidavit of Marjan and Professor Gulier. Members of certain political parties decided that it was time to stop a process that had already started. We all watched in horror on TV as members, some of them who were in this court, confronted the chairperson, threw down the pulpit where he was to announce the results, threw down chairs, assaulted the chairperson and the commissioners. In fact, Professor Gulier, the chairperson, and the CEO were injured. And we have attached documents showing the injuries that they sustained. And the intention was to stop the declaration from being made. Now, this is critical, my lords. Everybody has said why it is important that a government should not be established by means other than those set out in the Constitution. But equally, nobody should stop the process of the Constitution that result in the establishment of a government in accordance with its provisions. Stopping that process is equivalent to preventing the Constitution from being effected. It's a transgression against the Constitution. And it cannot fall from the lips of those people who tried to stop that process to come before you and say the results of 27 constituents were not publicly announced, and yet you are the one who precipitated a situation where there was disorder, there was chaos. And this chairperson and the members of the commissions were now in fear for their lives. How do you tell them to still turn up and come and undertake an act that you have prevented from happening? And my lords, in the second petition filed in 2017, my lords, at this time also remember, this is a time when one of the officers of the commission had been abducted, the other one had disappeared and feared to be dead and turned out to have been murdered in any event. This is the situation that was prevailing at that time. My lords, faced with this situation, this court in 2017 in the repeat election was categorical that you cannot foment trouble, you cannot foment chaos, and then try to use the chaos as your reason, or the non-performance of an act because of the chaos, as the reason to come before this court for relief. My lords, it is critical that it becomes clear to political leaders that the decision as to who will be the leader of this country is made at the polling station. The agents, the commission agents who declare the results are just doing their job. If there is a problem, if the numbers of the votes that you got are not enough, the problem is not at the declaration. The problem is with the people who you did not persuade to vote for you in sufficient numbers. That is where the problem is. You cannot come to threaten members of the commission for purposes of them living in fear and refusing to do what they're required to do under the Constitution, and thereby enable you achieve a political purpose. And so, my lords and my ladies, the 27 constituencies, the critical point is, the results from those constituencies were tallied, were verified in accordance with the provisions of Article 138(3)(c). And you will notice that Article 138(3)(c) does not talk about announcing the results in the constituencies as a precursor or what will justify or validate the outcome. It doesn't. Lords, the next area that I just want to quickly go into, and I will just mention this in passing, the purposes for which we come to this court is that once they have made a decision, we don't revisit it. The question of the rejected votes, which I had been referred to yesterday, was determined in 2013. In 2017, Raila won, 2017, the issue again was raised, and this court said with finality that the only votes that will count are those votes that are valid. It's just valid votes. A vote that is rejected, a vote that is spoiled, does not express a choice, and therefore cannot count for anything. This court pronounced itself again in 2017. My lords, we cannot keep coming back before you and asking you the same question. You have answered it twice. I don't think I need to say more about it. The last item that I just want to deal with is the issue of constitutionality of certain regulations, which was raised by one of the parties. My lords, all I need to say about this again is that the provisions, these regulations, were promulgated on 27th of April 2017. They were the ones that were used for purposes of conduct of the 2017 election, first one, and of the repeat elections. No one has ever complained about those regulations. No application has ever been filed regarding the constitutionality of those regulations. In fact, when you retire to write your ruling, you will find that in both instances, this court relied on the provisions of Regulations 83 and Regulation 87 as the basis for the findings that were made, including the role of the chairman and the requirement for him to verify and tally the results of an election. And so, my lords, to now come late in the day, after you were made aware there is an election that is coming, you participated in those elections knowing that those regulations are there, and then when you do not succeed, you turn around and say, in fact, one of those regulations that were used is unconstitutional. That's one. Two, the law is clear, and I set out in the decisions that my ladies and my lords made in 2017 too, where you said that the determination as to constitutionality cannot affect antecedent acts. It can only look forward. So that even if there is a finding of unconstitutionality, and my humble view is that there is nothing unconstitutional about it, my lords, that cannot affect the election that was conducted on the basis of a law that was valid then. And so, my lords, it's my humble submission that this issue of whether or not the regulations are legal or not, my lord, is a small screen, because these parties, and especially the main petitioner, has been aware of this regulation and has participated in elections where this regulation has been used, now for the third time. The last item, my lords, is on the question of the postponement of the elections. Again, my lords, this has been explained in the affidavits that have been sworn by Mr. Gulier and also by the chairperson. And what happened is that the ballot boxes that were delivered, they had a mix-up in the names and the photos. And my lords and my ladies can imagine the confusion it would cause if this election was allowed to proceed on the basis of those ballots. Now, because of the deficiency of trust in this country, ballot pallets can only be opened on the eve of the elections to avoid a situation where IEBC is accused of having interfered or in any way manipulated the ballot papers. And so they were opened on the eve of the elections, which is on the 8th, and that is set out in the affidavit, when this mix-up was noticed. My lords, there was absolutely no time for fresh ballots to have been printed and delivered in time for the elections to be held. And therefore, in pursuant to the provisions of Section 55B of the Elections of the Elections Act, IEBC considered that this issue was an emergency. And what is an emergency? An emergency is an unexpected issue that requires immediate action. That's what an emergency is. And this was an issue that arose on the eve of the elections. These ballot papers could not possibly have been given to the electorate and told to use them for purposes of the election. And it is for that reason that IEBC, for purposes of securing the rights under Article 38 of the Constitution, decided to postpone the election to give the electors the opportunity to use the proper ballot papers for purposes of this election. And the mix-up was admitted by the printer. And what the printer did is that they agreed to print those ballot papers afresh at no cost. Now, my lords and my ladies, if we had used those ballot papers, obviously, we could not have been able to get a reprint at no cost. And secondly, for sure, there would have been a petition on the basis that there was confusion arising from the mix-up in the images and the names. And so the postponement of these elections was justified in the circumstances. My learned friends dwelt at length on what the chairperson is alleged to have said in a public statement. My lords, these are newspaper reports that are given from time to time. And the important thing is, what does the law say in situations such as this? Does the IEBC have the power to postpone the elections? And the answer is yes, because it secures and protects Article 38 rights. My lord, the second issue that, and this is the court will take judicial notice of this, is that there was ongoing litigation in Mombasa regarding the gubernatorial seat. And this litigation went on up to close just before the elections were concluded. And so, my lords, again, this caused delay in terms of the timing of when those ballot papers would arrive. So, my lords, importantly, before the ballot papers were brought, the commissioners that are complaining all traveled to Greece. All four of them traveled to Greece to review and see how the printing was going on. They were the ones who represented the commission in Greece. And so, my lords, for them to now say that there was no, that this was an error, that it cannot come from their lips. They were there, my lord. So it's a humble submission that based on what we have submitted, that the elections were conducted in accordance with the provisions of Article 138 of the Constitution, and that these petitions should be dismissed with costs. That's all, my lords.
May it please you, my ladies and my lords. For the record, my name is Eric Gumbo. I will be addressing the first, second, and third issue in the addressing you on those issues. Dated the 26th. Rely and the affidavit of Hilda Cavo. So coming to the first issue, which is whether the technology deployed by the IEBC for the conduct of the 2022 general elections met the standards of integrity, verifiability, security, and transparency to guarantee accurate and verifiable results, I will take a few moments to demonstrate how the technology that was deployed in the just concluded elections then met those constitutional imperatives. As a starting point, my ladies and my lords, we may want to ask ourselves, what exactly is this technology that we are talking about? And in answering that question, perhaps a bit of context would be of help. In the period just before the 2007 elections, when we still were dealing with the defunct Electoral Commission of Kenya, the legislative provision then, the equivalent to our Section 44, was worded in very loose, perhaps permissive terms. It was that to the effect that the Electoral Commission shall use technology where applicable or as may be appropriate. After the 2007 elections, we had the Kriegler recommendations, which then, one of which was that we must employ, or we should employ, the use of technology in our elections. When we got to the 2013 general elections, there was a good attempt at using technology, but the various forms of technology that were used were not were in different platforms, so that there was a different platform for purposes of registration, a different platform for purposes of identification, and a different platform for purposes of transmission. That did not work very well, perhaps because of the inefficiency attendant to the system then. Came the amendments in 2011 to Section 44, which required then that the technology to be employed was one to be integrated, meaning that in that one solution, we had the solution, we had the option for voting. The second was electronic identification of voters and electronic transmission of results. Now, the question that we have before you today is whether, as conceptualized, that solution then meets the constitutional imperatives under Article 86 of integrity, verifiability, and accuracy. I will take a moment to just demonstrate how each of these would have been achieved. But when you retire, though, to consider the decision, I would invite your attention to specifically the affidavit in a very granular sense, how these imperatives were met. I then would want to talk, that is specifically paragraph 39 to 49 of the affidavit of Michael Ouma. I then would want to talk a bit to the process entailed in those three items. So have participated in elections are familiar with that process. That once the voting has been done and the polling station has been converted for, to the evening now for purposes of tallying and counting of results, we start by the counting in a very transparent manner. The presiding officers count each and every ballot, and I'm sure we've witnessed this, showing a vote for Gumbo, a vote for so-and-so, and a vote for so-and-so. Now, at the end of that process, they are then tabulated to give us Form 34A. How then is technology infused in Form 34A? Form 34A has internally identified security features. There are 8 in number. We have watermarks, we have UV potentials, we have microtext, amongst other security features. What is the significance of this? It is so that when somebody looks at the Form 34A, the original, it cannot then be confused for any other form, and that whatever it is that happened at the polling station remains an authentic representation of the will of the people. What then happens is that after that form has been tabulated, it is captured with a KIMS device. One copy is sent to the National Tallying Center. Another of that image is sent to the Constituency Tallying Center. And the presiding officer then collects all the, takes the Form 34A for purposes of the collation to the constituency tallying center. That, again, is to achieve the constitutional imperative of verification. When we get to the constituency tallying center, the returning officer has a back-end access to be able to load their Form 34B and transmit it to the National Tallying Center. Once that is done, they will then go with their Form 34A, together with their Bs, to the National Tallying Center for purposes of the verification and tallying at the National Tallying Center. Again, it is important to note that by the time the returning officer gets to the National Tallying Center, we have the image that is already in the portal. When they get there with their original form, an opportunity is then presented again for verification, for confirmation of accuracy, and more importantly, that in this election, because of the decision that was rendered by this court in the Raila Odinga decision in 2017, the Commission, in reconceptualizing or reconfiguring its electoral architecture, gave a public portal for people to be able to also follow, thereby meeting the constitutional imperative of transparency. It then meant that if I'd gotten my results from my village, my primary school where I vote, I would be able to follow those results all the way to Nairobi and take account and follow if at all there is anything that would have happened or changed. Then I must be the first person to be able to raise that concern. It should also not be lost that in that polling station, we have our agents, we have our observers. Again, to add to the fact of verifiability. So that then is the architecture of what our election pathway looks like. That said, it then must follow that at the polling station, if I am a candidate, I certainly must have interest in the outcome in that particular polling station. Because a copy of the results from the polling station would be given to me, I then should be able to communicate with my team, perhaps my national agent for a particular candidate, a particular party, to be able to demonstrate that what we got in member primary school and what has been transmitted to the National Tallying Center is one and the same. And that in the event that there's a discrepancy, it does not take magic to be able to point out that. Now, as to whether this technology was successful, Michael Ouma deposed in his affidavit that 46,201 KIMS kits deployed throughout the Republic worked out of the 46,229. It then leaves us just with about 200 KIMS kits, which did not work at the opening or start of election on that particular day. I asked myself, if out of 46,000 KIMS kits, only 200 do not work, would I say I've failed? Even in our educational system, an A does not connote 100%. It starts somewhere from 88%, going all the way to 100%. The mathematical representation of this gives us more than 99% success rate. In our view, that then achieved the constitutional imperatives that are contemplated under Article 86. Again, for purposes of confirming whether that system is secure, I invite you, my ladies and my lords, to look at paragraphs 51 to 63 of the affidavit of Michael Ouma. Again, just to mention a few items in relation to that, that KIMS gadget works in specific ways. It is first locked to a specific polling station, meaning you can then not use it once you've locked it to the events of that day to transmit results from a different station for purposes of that election. That the entire network through which the results are transmitted are secured or double layered with firewalls, meaning there's the first firewall and the second firewall for purposes of securing that transmission. Very significant again to mention that at the point at which that image is to be transferred, it is encrypted. So as it is transmitted, it is not in the form of what we would imagine the image of Form 34A. If I was to use an example, if it was to be a water pipe and it is to be encrypted, it means if you broke into that water pipe, because we all know that the chemical formula of water is H2O, you'll get your hydrogen on one side, you'll get your oxygen on one side. It then means you'd not be able to make sense of that water that you're looking for. Again, we must be able to relate this with other factors. In the KIMS kit, we have certain information that is resident, close of business in any polling day. One of them is the question as to the voter turnout of a day. It means for somebody to intercept that system, they must have information in relation to the voter turnout of that day. It may not be practical for somebody to say that they have the capacity to know the voter turnout throughout the country at the second at which they want to intercept a particular form transmitted. Again, if we exceed the number of people who voted, then again, from an accountability perspective, it would be very easy to point out to say, because of the fact of this interference, you've exceeded the numbers of what was captured in your report. To give further comfort, this transmission is done over a virtual private network, which is provided by the mobile network operators, who themselves also secure that environment to ensure that there is no intrusion or interference coming from any quarter into the system. For a good, perhaps, mental understanding of what this means, or how this was applied, Michael Ouma in his affidavit says that there were more than 380 million hits on trying to, just to access the public portal. And that according to him, none of the systems even blinked. That is how secure that environment is. Now, the other question that somebody would want to look at in relation to Article 86 is the compliance with the provisions, statutory provisions in relation to procurement and all those. Again, I invite you, my ladies and my lords, to look at paragraph 64 to 71 of the affidavit of Michael Ouma. He then ends at saying that close of business, more than 14,239,000 people were successfully identified through that system. He describes it, to use his words, as a military-grade system. That is how comfortable he is with that, with the security features of that system. I come to the second question, which is whether there was interference with uploading and transmission of Forms 34A from the polling stations to the IEBC public portal. The emphatic answer is no. I have given a general description of the infrastructure that was laid out. I will take a few moments to demonstrate that it wasn't possible to get into that system, and that even if somebody attempted to get into the system, then it would have been noticeable, to again speak to the fact of verifiability, and that one would be able to pick that with pinpoint precision because of the manner in which the system works. For purposes of a clear understanding, it is purely because of that verifiability that we are able to hear our colleagues appearing on this other side for the petitioners saying that they saw a gentleman called so-and-so who accessed the system. so and so access the system because of verifiability. It means that those who were able to access the system must have been people who were then authenticated to access the system, because certainly you must get some human intervention if the system is to work. To this extent, we'll then invite you to look at the affidavit of Hilda Kavonga. Hilda Kavonga is the manager, security and business continuity. Again, Hilda confirms emphatically that the system was not breached. She speaks at paragraph 7 in good detail about how robust that system was. I invite you, my ladies and my lords, to look at the structure of that infrastructure and just appreciate for yourselves how then it was secure for purposes of protecting the will of Kenyans. At paragraph 12, she even goes on to give security assurance through certification from the National Institute of Standards and Technology. Now, we look at this in relation to the allegations that have been made. There's an allegation about staging. Learned counsel, senior counsel, Philip Murgor, spoke about the man in the middle. The indication or the allegation appears to be that somebody intercepted the system or broke into this system, downloaded this form, altered this form, uploaded it again, and sent it or transmitted it to the National Tallying Center. Like I said, when eventually we have an opportunity to look at the details that we have submitted, including the KIMS returns, it will be apparent that there was no such intrusion. But assuming for one moment that we want to interrogate this fact of staging, we then would want to ask ourselves, at what point in time did this happen? Because according to the infrastructure that is laid out by the IEBC, once a form is transmitted from the polling station and it gets to the public portal, it also has certain inbuilt security components. It has a digital signature. That digital signature marks an indication as to the exact time when that form was transmitted. If there's intervention, then certainly there must be a lag between the time when that form was transmitted and the time the form got to the National Tallying Center. It is our submission that nothing has been presented before this court to even come close to making that suggestion. Again, as part of the security that is in the portal, each of the forms that get there are serialized. And the serialization is tied to the polling station. It is tied to the date, to the time, up to the second when that form was received. It then, as an additional property, gives you a tab to be able to confirm or verify whether there's been any alteration on the form from the time it was transmitted. One would then very easily pick up that as a concern to say, we refer you to, again using my primary school in Member Primary School, that the form 34A that was sent from Member Primary School was intercepted, manipulated at this point in time. That is a report that the portal would be able to generate. Again, not a single piece of evidence has been given to come close to suggesting this. I've pondered since the submissions and presentations yesterday from our learned friends appearing for the petitioners as to what really this evidence is. I have, in the course of struggling to look for this evidence, come across three possible areas they'll be talking about. In the affidavit of one John Mark Gidongo, they make reference to a form 34A from Baringo County, Tiati constituency. They then say that that is an example of a form that was intercepted. Michael Ouma, in his affidavit, confirms that in fact the form that was uploaded or that was attached in the affidavit of John Mark Gidongo is not a form that arose from the process that, that they allude or allege it arose from. That according to him, this form was downloaded. Somebody tried to interfere with the details on it and attached it to an affidavit. Now that, if you asked me, is perhaps the silliest way of doing any of these things, because if somebody asked you whether that form was authentic, you only need to look at the public portal. You then need to verify it with the Form 34A that was presented. My ladies and my lords, as a statutory requirement, we delivered all the Form 34As to this court. We have a copy. The entire public has copies of each and every of those documents. Our team went through those documents, and in relation to that specific Form 34A, to say the least, it's a forgery. The second attempt, again by John Gidongo, in his affidavit, to try and present some form of evidence, is in the form of logs, which were alleged to have been gotten somewhere. It says Karen, with these 56 mysterious people, and this, I think, is what senior counsel Professor Githu Muigai was talking about, hearsay on the back of hearsay. I was told that I had. Really, is that the sort of evidence that we want to present before this court? We took time, that is, the ICT team took time to study the logs that were presented. My ladies and my lords, I'm sure you have appropriate infrastructure to be able to make a determination on your own as to what these logs entail. From the analysis that were conducted, and this is again contained in the affidavit of Martin Nyaga, these forms, these logs, arose potentially or were picked potentially from the 2017 general elections. Martin Nyaga, in his affidavit, identifies 9 obvious inconsistencies. I want to allude to just 2 or 3 of them. That, if you, and that is in paragraph 13 of the affidavit of Martin Nyaga. If you look at the manner in which those forms, those logs are structured, they serialized, in 2017, the IEBC serialized its logs using the names of the constituencies. In that particular log, you'll find a name Changamwe. This time round, they did not use the names of the constituencies. They used the serial numbers. So that is a first inconsistency. Looking at those logs again, you see the name of one Asenge running an IEBC email account. Asenge was one of the returning officers of the IEBC in Changamwe in 2017. One is then left to wonder, at what point do we get to even forging documents, forging logs, to be able to demonstrate our case? Perhaps I will get to that a little later. Enters the third piece of evidence, which was supposed to now clean what was presented by John Mark Gidongo. The affidavit by one Commissioner Justice Nyang'aya. Commissioner Justice Nyang'aya attaches logs to his affidavit. He then emphatically indicates that those logs go into confirming that specific named people accessed the system and that they then interfered with the results. He names 3 officers from the IEBC. Their details are in the affidavits. My ladies and my lords, again, we took time to run through those logs. The logs that were presented in the affidavit of Justice Nyang'aya, according to the information from the ICT team, and this is to be found in the affidavit of Hilda Kevongo. One, do not speak anything towards identifying any of those names that are contained in the affidavit of Commissioner Justice Nyang'aya. In fact, according to Hilda Kevongo, those logs speak to the ordinary applications that run the systems in IEBC on a day-to-day basis. If you read through them, because they're written in English, you'll find indications like daily update completed, news downloads for the day completed. At no point throughout the 7 or 8 pages, which is supposed to be a representation of the logs, does any of the names of these individuals feature. One then is left to wonder why such an inconsistency had to come in the manner in which it came. We have had allegations about certain named individuals. There's been an allegation about one Abdidahir Malim. My ladies, my lord, Abdidahir Malim was one of the returning officers, duly gazetted for purposes of this election. Like I earlier said, he then had access limited to the singular purpose of transmitting the Form 34B in relation to the area he was presiding over. That, therefore, is an authorized person. And indeed, Hilda goes on in her affidavit to confirm that all those other people who were mentioned were people who were duly authorized. There is the heavy weather that was made about the Venezuelans. A specific name has been dropped of one Gaidino Omar. My ladies and my lords, the contract between Smartmatic and IEBC was for the supply and maintenance of the infrastructure that they had. It then meant that they had to bring their personnel to manage or just monitor the smooth running of that system. Of significance is that Hilda, in her affidavit, then goes on to say that before the election, these people were all logged out of the system, and that on the date of the election, none of these people was in the system, even for purposes of that maintenance. My ladies and my lords, it would make a lot of sense if somebody said that so and so got into the system and they interfered with the system in this manner. It is not enough for somebody to say Gumbo was found in the system, because what matters here is the allegation around manipulation and alteration of the results. Now, if we do not get into this space, what exactly are we talking about? I would want to again equate this to a situation where in your house, you decide to assign a plumber to do for you some work. When the plumber comes to do the work, then you raise an alarm and say, oh wait, there's a plumber in my house. How is a plumber to do the work that he's supposed to be doing in the house? Certainly, it does not make much sense. If you expect the plumber to fix the plumbing problem, then certainly you must give him access to the plumbing problem that you have. Now, I have looked at, and we've tried perusing through all these documents. There is not a single form that has been presented which appears to suggest, even in the lightest of ways, that there was any interference. And again, just relating this to the architecture of our elections, if at all there was any such interference, it would have been an interference that goes into the numbers. Now, because we have not seen that, is this the case then, therefore, why numbers has become a very dicey and perhaps an area where everybody would want to avoid or run away from? In the petition, I suppose the first and most important thing is you must demonstrate that you had specific numbers. Even if there's to be contest, let it be contest between this set of numbers and the other set of numbers. It can't be a contest between the man who was said to be the man in the middle and numbers. If that man was in the middle for sure and he had a job to do, then that is a man who slept on his job. Because we are not shown anything that he perhaps could have done while in the space that he is alleged to have done anything that would have interfered with the will of the people. Hilda continues to wonder in her affidavit as to why their boss, who is a commissioner, would expose them to that extent that they mention names of people who are employees and staff of the institution doing their legitimate work. Then you cast aspersions without basis that they were engaged in a criminal enterprise. My ladies and my lords, it might sound like a light issue, but we must have seen it in social media, in mainstream media, that these people, who some of whom ran this election, have had to go into keeping house. They've had to go into hiding because people read these sort of things and they imagine that this is the gospel truth. Certainly, this is not a light issue. Yesterday, there was extensive submission as to whether this court is handicapped in terms of dealing with some of these things. Now, as the IEBC, on the one hand, tries to improve the system based on the law and the guidance from this court, I think there's also a responsibility that should attach or follow where we have very deliberate attempts at misleading the court. If we look at, for instance, the logs that have been attached by John Mark Gidongo, if it turns out to be a forgery, does it not disclose an offense? It is not in my province to make that determination, but where I see it, it bothers me because as we go into elections this year, in 2027, we need to then sanitize some of these things that we do. And one of the ways of sanitizing them is by holding people to account, so that if you present evidence that is obviously not true or that is falsified, then you must stop to ask yourself whether there would be a consequence or not. That is the only way through which even this court would be able to sit, to be able to determine or preside over any of those matters that are presented with ease. I need to add that at the Bomas, which is the National Tallying Center, when the returning officers got to Bomas, what happened? Now, in the floor of Bomas, these returning officers would come with their original Form 34As, hand them to the national returning officer for purposes of a presidential election. After that, they would be subjected to an ICT team, and that ICT team was not sitting in isolation. They sat with the agents of the parties, they sat with observers, and what they were doing was to again confirm those security features we had spoken about. After that, they went into the detail around the numbers, comparing what they had in the Form 34As that were in the portal and the Form 34As that were then presented, the physical hard copies. From the direction and guidance of this court in 2017, Raila Odinga, what the commission was to do was to record those errors. I confirm, my ladies and my lords, that the commission did exactly that. The error report has been availed to this court, but of significance is that as they were preparing that error report, a copy of that error report was also availed to the agents of all the parties. This is important in the architecture of our elections. It is important because as opposed to asking the court to now go through scrutiny. It will be a question of saying, wait a minute, in the error report, there's a difference between the results that came from member primary school, which I have either in my carbon copy from my agent, or that was presented by the returning officer, and what we are now seeing in the portal. That is the only way through which somebody could make an allegation that would stand the test of time. If you have that, then certainly, if you apply yourself in the, to understand the architecture of our electoral platform, then there is really no need to go into scrutiny, because that report is scrutiny by itself. In fact, it was a forensic audit. They had their watermark readers, they had their UV light readers, and these are things that are all contained in the affidavits of these three individuals that I've spoken about. When you take time, you look at that, and it is then our submission that to the extent that there is an allegation that there were interferences or that there were differences between the Form 34As in the portal and the Form 34As physically presented by those returning officers, there was none, and this is verifiable. Indeed, none has been presented before you. The last issue I'm to deal with is whether there was a difference between Form 34As uploaded on the IEBC. Sorry, I think I've got into that point as well. And so, there was a question that was raised about Form 34C and the concern about the multiple entries. Submission was made by counsel that the Form 34C is supposed to be generated once. Again, that sort of submission would only come from a false, if not limited, understanding of the process. I say that because as the verification and retallying of the Form 34As were going on at the National Tallying Center, whenever they completed the verification and retallying of a constituency, they would then upload it onto the Form 34C after the completion of the verification. That then meant that that process had to be an incremental process. That is why when somebody says that there is a gentleman called so-and-so who accessed the server or the rear end of the result transmission network 1,000 times, it simply speaks to the fact that they had to make entries. It should not be lost that we were using, according to the jurisprudence in Maina Kiai, results from the polling station, which is the original Form 34A. Now, if we look at the number of the polling stations, it speaks to about 46,000 and a few hundreds. It then meant that a corresponding number of entries, entries had to be made on that Form 34C. And that, because I'd said it is supposed to be done incrementally, I would want to refer for clarity again to the affidavit of Commissioner Justice Nyang'aya. At paragraph 51 of the affidavit of Commissioner Justice Nyang'aya, he says, or he acknowledges, that indeed it would be inaccurate, impractical to expect the 7 commissioners to be the ones to do all these specific assignments that the commission is supposed to be doing. Similarly, and by parity of thought, when the law says that the commission shall, for purposes of this, generate that Form 34C, the law does not contemplate that the chairperson of a commission will sit with a laptop and make 46,000 plus entries by himself. This is what my learned senior counsel Kamau Karori was speaking to. This is what is contemplated under Section 11 and 11A of the IEBC Act. And so, if we then tie this to the submission that he had earlier on made, that if we read under Article 138(3)(c), the Independent Electoral Commission to mean the entire institution, then we would not run into the problems that we are running into. Because as we saw, and as will be demonstrated in by our subsequent speakers, that exactly is what happened. The entire bureaucracy or the entire institution of IEBC participated in that process. As I conclude, I want to make a submission that when we make these allegations in our election petitions, perhaps we need to also ask ourselves if we have done that which the law contemplates of us. And that if the law gives you an opportunity to choose your agent for purposes of verifying or speaking to you in relation to the processes in the election, if you fail to present an agent, would it be appropriate to then come and burden the subsequent processes through applications such as what we're seeing for scrutiny? Because the law contemplates that that agent should be able to point you to the fact there's a problem in a particular primary school. Go there. Don't ask for the entire of a constituency. Don't ask for the entire of a county. And I think that has been the jurisprudence that has been developed. It then follows that we must sanctify the place of agents in our elections. And because agents are like our spouses, you choose your own. You choose the one you trust. If you get one, nobody imposes an agent on you. If you choose one you don't trust, then really you can't blame anyone. If you choose one who does not understand why you assigned them that responsibility, again, you cannot possibly blame anyone. So, as I seek to take my seat, we ask, my ladies and my lords, that
My Lady the Chief Justice, the Deputy Chief Justice, and the members of the Supreme Court, it's indeed a great honor to appear before you in relation to this petition. My role today here is to take you through the numbers. I will take you through the numbers. The numbers will be running on the screen.
Your name, please.
My name is Mahar Somane Advocate. My name is Mahar Somane Advocate. I'll take you through the numbers as it relates to the petition that has been filed. I will also give you an audit trail of mechanism which the court can use to measure the petition. The first question that I'll answer today relates to the question that has been put to us. And the first one is whether the postponement for the constituencies in Kitui. Your Ladyship, if you look at the constituencies for Kitui, the voter turnout for Kitui Rural was 60.29%. So for us to actually make a comparative data and analysis to actually see whether there's been voter suppression, we look at the constituencies nearby and see the data we are getting from the constituencies nearby, whether the inference can be made by this court that there has been voter suppression. The voter turnout for Kitui Rural is 60.29%. I have highlighted in yellow in your screens. It is comparatively similar to the voter turnout in Kitui Central. In fact, it is Kitui Rural is higher. Kitui Central is 60.10. It's comparative to Mwingi Central. So to the question the court asked, whether there was voter suppression in Kitui Central constituency because of the postponed election, the answer is an emphatic no. I will go to the second question. The second question the court asked is whether the postponement of elections in Kachaliba and Pokot South led to a voter suppression that led to a low voter turnout in favor of the petitioner. The answer is data-based. I have provided the comparative analysis. I want the court to look at it. The voter turnout for West Pokot was 81.44. The voter turnout for for Kachaliba was 81.44. I have highlighted in yellow. The voter turnout for Pokot South is 80.44. It is higher than Kapenguria. It is higher than Sigor. Comparatively, in fact, those voter turnouts were higher than the ones which the elections were not proposed. That claim falls flat on the data that were provided to court. I will proceed. I will go to Rongai. The question the court asks is whether the postponed elections in Rongai led to suppression of voter. I have provided the data on Rongai. The voter turnout of Rongai was 61.41 for the presidential. It is higher than in Joro. It is higher than in Naivasha. And it's comparatively similar to the other similar constituencies. To the allegation that there was voter suppression in those places because of the election that was postponed, that allegation is untrue, falls flat on the data we have provided. To the other question, whether the postponed elections in the MCA ward for Nyaki West led to voter suppression, the voter turnout for Nyaki West was 64.32. If you look at North Imenti, it was even lower. It's comparatively similar to the other we have provided. To that allegation, that falls flat on the data and the comparative data we have provided. To the allegation that the MCA ward in Kwanjenga, that there was voter suppression because of that, the MCA ward in Kwanjenga, the voter turnout was 46.32, comparatively similar to Embakasi South, which is 49.62, comparatively similar to Imara Daima and also in Pipeline. To that allegation, when you look at the comparative data, it's not a matter of hypothesis, it is not borne out by the data. To the allegation that the postponed elections in Kakamega led to voter suppression in terms of the petitioners' votes being undercast, the allegation falls flat on the comparative data. We have provided the data for Vihiga, which is similar. Bungoma was a bit higher, but Vihiga is the same. So comparatively, when you look at those data points, that allegation falls flat. To the allegation that in Mombasa, there was a voter suppression because of the election that was run, I want to point out, even in 2017, the general voter turnout in Mombasa is generally very low. That data is available. It's always lower than the other constituencies. But comparatively, it is almost something that is comparable. To those, so I have answered. So to the question that the court put out on the comparative data, the answer is there was no voter suppression in those places. Senior Counsel Kamau Karori has already explained on the reasons why those elections was not held. There was nothing premeditated about those elections, not holding those elections. Reasons have been given in the affidavits of the chairman Wafula Chebukati and Marjan Hussein Marjan. So to that allegation, we want to show the court the petitioners have a hypothesis. We have provided the data to the court to actually aid the court to come to a conclusion. The second question I want to answer that the court put out to us was whether there are unexplainable discrepancies between the votes cast for the presidential candidates and other elective posts. Indeed, if there was unexplainable discrepancies, is a grave issue, which we know. We will show through the data that we have provided to the court that the same is not true. In fact, we can account for each ballot. To just guide the court, refer to the affidavit of Moses Ledama Sunkuli, which is on record. We have provided the comparative analysis. In fact, what I did is we provided the 34C, the 37C, 38C, and 39C. Those are the forms for the governor, the senator, and the women rep. We tallied against the presidential. I want to refer the court to paragraph 36 of Moses Ledama's affidavit for the court to look at it. And if you do a tally, and we started with a tally for Senate, if you do a tally for the votes that were cast for the Senate, vis-a-vis, and that, Your Ladyship, that runs from page 13 of Ledama's affidavit up to page 15. And I just did the summary analysis, but there's a very big comparative table that I've put out there. If you do the analysis, you will come to the following conclusion. What is the voter difference between the senator and the presidential? 500 votes, the variance. And how do we account for those variants? So when you do the presidential like for like and the senator, you will get a difference of 22,801. You have to minus diaspora voters, which only vote for the presidential. You have to minus prisons, which only vote in the presidential elections. Okay? And then you have to look
at stations which were affected and did not have any results for any of those elective posts. For example, in some of the stations, some few stations, some violence happened. Likely they did not report for Senate. When you do that analysis, you will get the differential is 500 votes. I have done an elaborate analysis also on the stray ballots. When we get to that, I will explain. So the differential between the Senate and the presidential is 500 votes. And that 500 votes, we can account for in stray ballots. I have attached the polling day diaries for Kibra and Makadara. I have done an analysis to actually check what is the stray ballot per constituency. And this tally is like for like. So to the question whether there was a discrepancy between the presidential and the Senate vote, the answer is an emphatic no. It is explainable by looking at what the information that we have provided. To the second question, whether there was a discrepancy between the women member of National Assembly for the women rep as compared to the presidential, I will tell the court to look at page 18, page 17 and 18 of Moses Ledama's affidavit. And our answer is there is no much difference. And the differences can be accounted for. The variance analysis we have provided. To the question whether there was a and it's shown there. So to explain, and this is how we understood the court to mean the duty of the IEBC is to explain each ballot cast and track that ballot to see where it has gone. So once we do the analysis for the presidential and we remove the prison voters, once we remove the people who voted for diaspora, once we removed some of the small polling stations that did not report for any of those seats, you will see a small variance. So we thought the court will ask where that small variance is coming from. And so what I did is we went and we went to sample one of the constituencies in Nairobi. And in one of the constituencies, Kibra constituency, we got 405 stray ballots. So you can't account for the way it will work is it will take from any of those ballots small incremental numbers. So you will see a variance of 500 here, 200 here, but cumulatively it is not something that cannot be explained. And I have attached all the polling day diaries. In fact, if you look at the Form 34A, which was supplied to the court, some of the comments section will indicate that they found some stray ballot in the presidential ballot. But to the court, whether there is discrepancy between the senatorial, governor, and the women rep seats, as compared to the presidential, there is none. We have demonstrated that with data. And even when there's a small variance, we have shown the stray ballots that cumulatively over those 3 seats, that will be there. A question was, a submission was made by learned counsel, Ms. Julie Soweto, that there is 33 per polling station stray ballots in Kirinyaga. I will explain that. I don't know what numbers they are using. It's an old litigation strategy in numbers for shock and awe. I think what they are trying to, if you look at the numbers for Kirinyaga, there's no difference between presidential and the governor of 22,000. In fact, the variance is 900 votes, which can be explained for by the stray ballots. The number they have indicated for governor, I don't know where they have gotten it from, is not what is in our 37C, and we've indicated that in our submission and also in our presentation. So to the question that the court asked, that whether there are inexplainable discrepancies between the votes cast for presidential as against the governor, for presidential as against the women rep, for presidential as against the Senate, the same is not borne out by the data that we have provided to the court. Now I'll go to another issue which was made heavy weather of by learned counsels on the voter turnout. Justice Moki Wanjala asked, how important is the voter turnout to the actual valid votes and to the actual declarations. Of course, it's an important issue. The only problem with it is that council are not understanding how we calculate voter turnout. And I want to explain to the court how voter turnout calculation is done using the kits. Pursuant to the Maina Kiai case, the court was very emphatic that elections must be conducted at the polling stations. And pursuant to that, voter turnout reporting is done per polling station. So how do we do it? When the polling station opens and Kenyans are voting, depending on the network access of the kits will be sending us information every 2 hours. They will giving us, the kit will be telling us 200 people has passed by this kit in this polling station, and that information will be collated until the end of polling day. So 2 things to note here. The first one is that the reporting is done per KIMS, per polling station of the reporting KIMS. So for example, on the 9th August 2022, when the polls closed, the IEBC gave a turnout figure of 56.1679%, which is the percentage turnout. That correlated to the total number of registered voters in those schemes, in those polling stations. The problem that the petitioners are having, they're saying these 56.1679% you announced must be of the total people in the register, which is 22,140,258. 120,258. We don't do that. We report per KIM. So if 200 people reported in that KIM and the number of registered voters is 600, we say 200 of 600 voters. We add the next KIM, 300 people have reported, we say 300 over 600 voters. The next KIM, 400 KIMs have reported, 400 over 600. We keep on aggregating until we see how many KIMs have reported of those polling stations. Why do we do that? Because of 2 reasons. The first one is, which is in the affidavit of Hussein Marjan and the affidavit of the chairman, because of network issues in some places, far-flung places in Kenya, some of those KIMs will report late. Some of those KIMs will report much later. So if we did a number over the total number of registered voters, we'll be giving a false turnout. So the turnout we give is based on the aggregated voters of the reporting station in that KIM. So if you took when we announced, the 56.1679% is based on the total registered voters in those stations who have reported in those KIMs, which was 21,481,642. Your Ladyship, you'll realize this is much lower than the total number of registered voters. And we'll keep on accumulating. KIMs will keep on reporting. 235 polling stations went manual. We will have to later on aggregate the 235 polling stations which went manual. Then we come with a total voter turnout. And if that is the reporting we do, 2 arguments that have been made in the petition of Omtata and in the petition of number 5 fall off. The first one is, their contention is that the chairman announced a turnout on 10th August 2022. That is the third line, Your Ladyship and members of the court, announced a turnout of 65.4%. What we have indicated is 64.6%. Your Ladyship, I will pause there to just inform the court that the chairman clarified that statement. The recording is in the affidavit of the chairman. And the actual clarification the chairman gave, he said that the total reporting polling stations, and if you hear his statement, it will give some clarification. We never say the total number of registered voters, because we will have that information when our manual count and everything has reported. We say total number of polling stations reporting, so in those schemes. So they're saying 64.6% must be of the total registered voters. That is their contention. That is their voter turnout. That is not the voter turnout of IEBC. The voter turnout as a percentage was, at that point, 64.6%. The number of reporting KIMs were 21,926,565. You will notice from this number, there are some polling KIMs which haven't reported. As they go to the constituency tallying center, those KIMs will report. You will also notice that we haven't included the manual count to give us a total figure of the total voters who will have registered, who will have reported. On 10 August, when all the KIMs returns have come from all the polling stations, the number of persons identified, that is the last number on the table, 14,239,862. As against the total registered voters in those stations which reuse the KIMs, 22,005,541, giving a turnout of 64.7103. You notice, Your Ladyship, we haven't included the manual count. So that is all KIMs in all polling stations. What remains now? Manual count. And this is important. I will pause there. We were very deliberate in trying to help the court in be able to identify and actually provide an audit process for the contesting parties' allegations. In the affidavit of Michael Ouma, we have attached 7 volumes of the KIMS returns for every polling stations in the Republic. Why is that important for the petitioners and the court? That is the first audit trail process. How is it at the first audit trail process of? We've provided the KIMS returns per polling stations in the Republic. We've also provided the certified copy of the 30A. So if anyone wanted to look at how many people pass in that polling station, you will look at your KIMS return, you will look at your 34A. And if there's any inconsistencies between the KIMS return and the 34A provided to the court, then question can be asked to our client. So in providing an audit trail process, the first way of providing an audit, which is both manual and electronic, is the KIMS return provided in the affidavit of Michael Ouma in 7 volumes, as against the certified copy of 34A we provided as per the regulations of this court. So we provided that. And if you look at those KIMS returns, they will correspond with this. They are from 45,994 polling stations. The number of identified by KIMS, 14,229,862. The total number of registered voters, 22,005,591. And the percentage is as indicated. We've indicated how many KIMS there were. And I just want to and after the aggregation of the manual and the KIMS, and that's the table that's there. So to the question, I think that is important for the court, and the court will ask, is the first question that the court will ask, what is the registered voters in the Republic? And I think that is not contested. 22,120,458. I think it's in the affidavit of everyone, that the register is publicly available, that can be accessed. How many polling stations do we have in the Republic? 46,229. How many people are registered in those polling stations? 22,120,458. How many polling stations were authenticated through using the kits? 45,994. How many registered voters are those in those polling stations? 14,239,862. What are the registered voters in those polling stations authenticated through the kits? 22,005,591. What are the polling stations that were not authenticated through the kits? 235, out of which 6 polling stations, 3 in Eldas and 3 in Quisero, there was violence. And no voting took place, in fact, at the time of that. And so how many polling stations went manual? Using complementary system, 229. What are the number of voters authenticated through the complementary manual system? 86,889. What are the registered voters in those 235 polling stations? 114,917. Why are these numbers important? They are important for audit trail. First, we have provided the KIMS returns to the court, which can be compared as against. Secondly, 99.9914% of Kenyans were authenticated through the KIMS. Less than 0.001 Kenyans were authenticated through a complementary mechanism. And the reason why I go back to that is giving the court an integrity check as to what we did. So if we are telling the court that 99.99% of Kenyans were authenticated through the kits, we have provided the receipts from those kits to the court, we have provided the Form 34A, then the court can compare and will bear out the work we did. Another allegation falls off. So what is the allegation in the Omtata petition? And I will go back to the turnout table, Your Ladyship. They are saying that the turnout announced by the chairman on 10th August 2022 must be over the total registered voters. That is where the mysterious 140,000 is coming from. So they are saying the 64.60 must be from the 22,124,058. We are telling them that is not how we calculate our turnout. It was very easy to confirm with us and ask us how you do it. We're telling them that number is out of 21,926,565. We could not do it over the registered voters because some stations went manual, some KIMS had not reported. How will we give a number over a total in which we don't know the status of some of those stations? Because the returns have to come for us to be able to give that. So they're saying 64.6 over the total voter turnout will give you 140,000. IEBC has not accounted for 140,000 voters. It's a lie. I think they are wrong on the maths, and they are wrong on the substance, and they are wrong on the substratum of how we are calculating that. And I think it's imperative that the court understands that. So the issue of 140,000 is not here nor there, and we have demonstrated that. And the second issue is they say that there was 110 voters error, 110 error in the Form C. By virtue of that, the Form C is not a valid vote. We have acknowledged that error. It's a data entry error in 2 stations in Kilifi and 1 station in West Pokot. It is the error form for the C is attached to the chairman's affidavit of 110. The Form C is a collation of 46,229 polling stations, and there is an error of 110 in which we have explained the data entry. I think that is not something that is material to the Form C for the court to say that a Form C is invalid because of an error which you have acknowledged. Your Ladyship, we also want to confirm to the court, we have done an error report for each and every polling station in the Republic. And this is going to be, and we really are craving for the scrutiny report to bear, and this will bear us out. That the voters, what Kenyans voted on the 9th of August is what was transmitted, and it's what was actually announced by the chairman. The will of the Kenyan people was carried out through and through. And that will be borne on by the scrutiny of those ballot boxes. That will be borne out by the information and the data we have given. And that is really, really important. The other issue I want to actually address is allegations that have been, Your Ladyship, if I could just go to the affidavit of Mother, I mean, this is what I was talking to. I mean, there's an allegation of paragraph 96 of the affidavit of the petitioner that alleges there's a variance of 25,000 between governor and president. The correct position is there's a variance of 900. It's worth noting the county is home to 2 prisons. And this is what the court should, and we can provide the court with, even if the court is inclined to even order us to bring all the original Form 34As and the Cs. We are ready and willing to provide that to the court. Some of these allegations, when you look at it, you really cringe that the allegations that are being made on these numbers, they have no basis. You will actually wonder how will someone write something like that in the petition? We have provided a tally of our the C series for the governor, for the senator, and the women rep. And we're ready to provide that to the court. We have put that in our affidavit. We are ready to provide whatever the courts will require to actually prove some of those numbers that are being banded. And some of these numbers are just meant for awe and shock, because it is very shocking to the court, to the conscience of the court, if you are told there are 25,000 people who walked into the polling stations in Kirinyaga, voted for the presidential candidate and did not vote for anyone else. It's really amazing. I will expect a variance because of the small stray ballots here and there, or maybe the prisons and diaspora, but it will not be 25,000. It's something should be that is explainable. And that is why the petitioners are wrong on the data, they are wrong on the numbers. And I will also demonstrate they are very wrong on even the ICT. I will add on to what Judge Eric Gumbo had also submitted. There are 2 allegations that are being made that the Form 34A, and I want to explain this to the court. So we have 3 audit trails or 3 verification processes for the court. The first I mentioned, it's the EVI, the electronic voter identification. We have given the KIMS return to the court. So the court will look at the KIMS returns and look at the AOL, the tally. The second one is when the Form 34A is being sent, and I've seen a lot of wild allegations being made, and I want to just explain this to the court. At the end of the polling, what happens is the kit, it converts itself into an RTS system, a result transmission system. The PO scans a QR code, it gives him a transition system. So it tells him, okay, Mr. PO, what do you want to transmit? Enter your PIN. He will enter his code. It gives him a query. You tell him, what do you want to do? He says, I want to transmit 34A. It tells him, okay, can you confirm the following checks have happened? And that's a validation check. Can you confirm that this form is signed by a PO? He says, yes. Can you confirm that this form is signed by a DRO, a deputy PO? He says, yes. Can you confirm this form is a 34A? He says, yes. Can you confirm this form has been signed by the agents? He says, yes. So after saying all that, then he tells him, take an image. And there's a lot of things being bandied here about the image. And we can provide, I think we've done training for the IEBC has done training for everyone, for LSK and the judges. And this is something that we can even provide if the kits are required. The kit takes an image, embedded in it, it has a scanner, and the image is embedded in the KIMS. So it's taking the image, and it's taking the image and scanning it as a PDF. We don't have any other output. We don't, and there's a reason why I'll explain to you why that input is being made, why it's like that for purposes of the security and the other purposes. He takes the image. It actually tells him if the image is not clear, it will tell him your image is not clear. Please retake it. So he takes his image and he presses send. That image travels from that, it is gone. He cannot recall. In fact, even if he does not have network, it will tell him the image has been sent. It will arrive when it will arrive. That image cannot be recalled in PDF. There's nothing that can be called. That scanned image in PDF, there's nothing that can be done about it. That is gone. When he gets a network, or immediately if he has network, it will hit our portal. Now, when it hits our portal, it's something akin to someone who's coming in the Supreme Court. The Supreme Court is established by the Constitution, and it has the jurisdiction by the court is limited by the Constitution. So those forms answer some jurisdiction questions before they are admitted into the public portal. What are those questions? So they ask, okay, you have come here, you have come into the court. If you want to sit here inside the court, answer the following question. They ask, are you a 34A? He says, yes, I am a 34A. Okay, do you confirm that you come from the code of the polling station? So it has a code of the polling station. So it will run against the polling station codes, it will confirm. Then it is asked, okay, we've confirmed you are an A, we've confirmed that you are from the code of the polling station provided to us, because all our polling stations have specific codes. Then we ask them, then it's asked the third question, do you come from a serial number of our kit? Then he answers, yes, I am from the serial number of the kit. If it is another form which is coming, are you from, if it's not from a serial number, it checks, it tells, no, you can't come in here, you have no jurisdiction. So it tells, do you come from a serial number of our kit? He says, yes. Then it's asked, do you come from the SIM card that has been